Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. And good morning and welcome to the Massachusetts Appeals Court oral argument session for February 10, 2022. That's right. This is one of two sessions going on today. As you know, this argument is being held on Zoom and live streamed on the Appeals Court's YouTube channel. So the panel for today in this panel is Justice Marguerite Grant, Justice Maureen Walsh, and myself, Greg Massing. If you're looking for the panel with Justices Mead, Blake, and Nyman, that's the other channel. We will follow the same rules and customs as in the physical courtroom, except that the lawyers can remain seated when they're speaking. Once we get going, the session clerk will display a countdown clock in the box with the insignia there. And each side has 15 minutes to argue, of course. As you know, there's no rebuttal. You're welcome to use all your time. There's no penalty for finishing early. Only one advocate will speak at a time. We'd like you to ask you to mute yourself when it's not your turn to speak, but remain on the video so we can make sure you're still here. At the same time, since we can see you, please keep your reactions and gesticulations to a minimum because that can be distracting. The proceeding is being recorded and archived, is and will be accessible to the public. As always, we've read your briefs, we're familiar with the case. In fact, your briefs and the record materials are on our computers and screens and tablets all around us. So if you see us looking away from the Zoom screen, it's not that we're not interested in your argument, but we're looking at case materials. So with that, I'll call the first case for today, which is Commonwealth versus Paris K. Tillery, 2020 P17. Attorney LeClaire.
Thank you, Your Honor. May it please the court, Jessica LeClaire for Paris Tillery. This case raises three very straightforward issues. The first is whether there was the facts admitted by the defendant at the colloquy established a sufficient factual basis to prove serious.
I'm sorry to interrupt you. I'm gonna stop right there. You're not raising a voluntariness or knowledge claim, right? You're raising a factual basis claim, right?
That's right.
So really, what the defendant agrees to or knows is sort of irrelevant. It's what the judge knows that's relevant.
It's what the defendant admits on the record that's relevant to whether there's.
If you look at the rule about accepting a guilty plea, a judge shall not accept a plea of guilty unless the judge is satisfied there's a factual basis. The failure of the defendant to acknowledge all the elements of the factual basis shall not preclude a judge from accepting the plea.
I understand, and I want to point out that this case is controlled by Rule 12C5 because Mr. Tillery pleaded guilty in 2012, and that is the rule that the SJC interpreted in Commonwealth v. Hart. So that's correct that there has to be a strong factual basis for the plea. Now, what the due process requires is that the defendant's admissions control what he's convicted of. So if you look at Blakely v. Walsh.
I'm disagreeing with you. That's on the knowledge and voluntariness strand. That's not on the Hart sufficient factual basis strand.
So I would say that what the due process says, you cannot increase a defendant's sentence on the basis of any facts other than those which he has admitted voluntarily and intelligently. So
under that, then Alford pleas are illegal.
I'm sorry, what was that question you
asked? Then you can't have an Alford plea.
Well, in an Alford plea, the defendant admits that the Commonwealth could prove its case.
Okay.
So, but taking that point, I would say that even if you are not saying what it is the defendant admitted, was there a sufficient factual basis, a strong factual basis in this case? And if we look at the serious drug offense case predicate, you're missing what we're saying is you're missing two key elements of that. And the first is, what was the underlying offense? Mr. Tillery unambiguously admits a school zone violation, but that is not a categorically serious drug offense.
But
So-
the indictment, the face of the indictment said possession of a Class B substance with intent to distribute, and a whole motion to dismiss under McCarthy was litigated. And at that hearing, the ADA said she was giving documentation showing what the underlying offense was. And that Judge McGuire, in denying the McCarthy motion, later noted that he had before him the printout of the docket of the Suffolk case. And he said that the offense was possession with intent to distribute, Class B. So why isn't that a sufficient factual basis that the defendant was previously convicted of possession with intent to distribute, Class B?
Well, there's two reasons. Number one, that record wasn't available at the plea colloquy. So we have no indication that the plea colloquy included the Commonwealth submitting some record showing there was a prior conviction of possession with intent to distribute a Class B. And what matters is the facts that are on the record at the colloquy. But perhaps more importantly, Mr. Tillery does not have a prior conviction of possession with intent to distribute, Class B. That indictment was based on a police officer's erroneous testimony to the grand jury, misreading the Board of Probation record. So there appeared to be no dispute in the lower court that Mr. Tillery doesn't have that prior conviction. And so
are you, just to be clear, are you representing to this court now that that Board of Probation record was accurate and he was in fact convicted of a school zone violation and not of a Class B intent to distribute?
Yes, I mean, so I've raised different issues in the lower court, but our position that I did not pursue on appeal, and I would posit that the only thing relevant to the sufficient factual basis issue is what he admitted on the plea at the plea colloquy. But yes, it's our position that the Board of Probation record and his memory, as stated at the plea colloquy, is that he has a prior conviction for a school zone offense. He doesn't have a prior conviction for possession with intent to distribute, Class B. The Board of Probation record indicates that there was a prior conviction for the school zone offense and that a distribution or dispensing a controlled substance was dismissed. Neither of those is possession with intent to distribute because those are two different offenses. And so that raises the concern here that, you know, if we're going to be imposing a sentence of 3 to 15 years on the basis of this prior conviction, we want to make sure that the fact finding is reliable. We shouldn't be imposing that amount of time if the Commonwealth cannot identify with clarity and precision what that prior conviction is. And if that evidence can't be marshaled at the plea colloquy accurately and reliably. So if that evidence, you know, if the admissions by the defendant in the court records are not reliable enough to know what he was previously convicted of, that evidence shouldn't be reliable enough to impose a 10-year sentence. And so that's one reason why we're saying that at the plea colloquy, they had to establish and he had to admit what was that prior underlying conviction. He admits the school zone offense, and there is he does acknowledge the prosecutor's statement of facts, but during a lengthy recitation of facts, he admits that it was a distribution of a Class B. He says yes. But then he goes on to clarify he was only charged with Class B and he was convicted of the school zone. So we're saying ambiguity is not okay. The judge, Judge McGuire, who denied when our motion was denied, the judge actually had to look outside the record to determine what was that prior conviction. And that's prohibited under Commonwealth v. Hart. So we're saying there's not enough here to justify that sentence if they can't identify that prior underlying offense. But that brings me.
Yeah, you're going to go to the ABW?
So that case is very simple. That's controlled by Commonwealth v. Ashford, where the SJC says assault and battery with a dangerous weapon is not a categorically violent crime. It can be committed intentionally and recklessly. Reckless offenses don't count.
Understood. And it's retroactive. But at the time, still at the time of the plea colloquy, that wasn't the case, right? So I mean, there was no, at the time of the plea colloquy, there's no reason for anybody to tell the judge about the underlying circumstance, because at the time of the plea colloquy, it was a categorical offense, right?
Well, that raises an interesting question. If the SJC says that we don't know that the force clause, the elements clause of the definition of violent crime, their interpretation in Ashford, they're interpreting that statute. And that statute says, according to them, reckless crimes, we can't count reckless crimes. So that definition, on the one hand, the defendant could not have known that that was how it was defined, but that definition is the definition of the statute since its inception. So at the plea colloquy, because the residual clause doesn't apply, there still had to be a factual basis to show that the assault and battery dangerous weapon fell within the meaning of the force clause. And what the force clause says is reckless crime.
But just answer my question though, at the time, that wasn't the case, right? I mean, at the time that this happened, there was no reason for anybody to go into that. I agree, if you apply it retroactively, we have to. But at the time, the judge, in 15 years, in 7.5 years, the SJC is going to say you're going to have to establish that that was intentional and not reckless. Right? That didn't happen.
Right. It's not the judge's fault that that fact wasn't found, or that, right? And it wasn't, however. So
at the very least, shouldn't and you say, and so therefore then the plea is insufficient, and you're entitled to not to withdraw the plea and actually an acquittal. So shouldn't the Commonwealth at least be given the opportunity to put that evidence in that there was never a chance to ask for it in the first place?
So I dispute that we're asking for an acquittal, and I understand, to answer the question, and I think ordinarily, if Mr. Tillery were still in the serving his sentence, that the sentence enhancement could be retried, but he isn't. Double jeopardy controls the remedy in this case because he has served his entire sentence. He served his entire sentence on the substance.
What should the sentence be on the 269-10A crime? Should it be a not guilty?
No, because we're saying that because the ACCA is a sentence enhancement statute, which the SJC has said it's not a freestanding crime, it only attaches to an underlying offense. The remedy goes to the sentencing. So what should the sentence be on the underlying substantive offense? That's a good question. I think that we have a remand for entry of judgment of that conviction and a vacation of the sentence enhancements. How that sentence issue gets resolved is an open question that I'm not aware of any case saying how that gets resolved.
Let's say that hypothetically we agree with you as to one of the sentencing enhancements, but not the other.
Yes.
Which, would have then meant that under 10GA, he would have been subject to not less than 3 years, not more than 15 years. Does this, if we were to remand, would that resentencing require any resentencing on the other charges?
No, and he hasn't challenged any of those other charges. He hasn't challenged any of his convictions. He's served his entire sentence on those, and he's fulfilled his end of the plea agreement by doing all of that time. So under double jeopardy, he can't be resentenced on any of those other convictions. Under
so
due
his
process,
criminal record would read 269-10A, Guilty, no sentence?
That's, again, perhaps that's a question that we could be litigating down below. I think that that's an open question, but he could be sentenced, he could, I'm not sure that the sentence needs to be modified.
Attorney Leclerc, does he have any probation on any matters currently?
No.
How, could you explain how it is that possession of Class B with intent to distribute is not categorically a serious drug offense?
We're saying that the Commonwealth has to, well, first he has to identify the controlled substance. If we don't know, this is a conviction that occurred almost 30 years ago. So without identifying what the precise substance is, we can't be really sure that that substance is still prohibited and falls within the definition of serious drug offense.
Well, if we were to go to apply as to whether it's still prohibited, wouldn't that be an ex post facto problem? Well, apply the law now as to what he was convicted of then? Isn't that your whole problem?
I think that would raise questions about that, but if you look at the statute, in 2010, I believe, is when he was indicted. If that substance was one that didn't carry a 10-year penalty, and we need to know, was the prior conviction, did it carry a 10-year or more penalty at the time in 2010, then it doesn't qualify as a serious drug offense. Now,
why wouldn't we be going by 1992 when he committed the serious drug offense?
Well, we could, in terms of whether the controlled, if we don't know what the controlled substance is, we also can't look at whether or not it was a qualifying drug in 1993. But
do you know if there are any controlled substances in the list of Class B controlled substances in Chapter 94C, Section 31, as it stood in 1992, that would not subject the defendant for a up to 10-year sentence if he possessed them with intent to distribute them?
I'm not aware, no, Your Honor, I'm not aware of any.
Okay.
Thank you. Are there any more questions? Then I would say thank you, Your Honors.
Thank you. Interesting. Well, we'll hear from the Commonwealth.
May I proceed?
Yes.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. So I think I would begin by letting you know I'm happy to answer any questions. I want to acknowledge that this is a difficult issue because, as I said in my brief, the law has changed greatly since the 2012 plea right up until the end of 2020 when Ashford came out. So, and that's applied retroactively. So I want to acknowledge all of that. And so that makes the case difficult to unravel. I'd like to start at the end with counsel's statement, appellate counsel's statement just now that the defendant is not seeking an acquittal, which I think is appropriate because acquittal is not a proper remedy on a motion for new trial. The proper remedy is to remand for a new trial if the defendant is actually able to show that the plea was insufficient. And in a case like this, where there has been plea concessions with 11 null process and a reduction in the ACCA charge from 3 priors to 2 priors, normally what happens is that the defendant's motion to withdraw his plea unwinds the whole plea and puts him at risk of all the prior charges that had been null prossed in consideration of the plea, as well as the reduced charge then goes back to the 3rd charge. So I understand the defendant saying he's abided by the plea and fulfilled his end of the bargain by serving his sentence, but the bargain is not just a sentence. The bargain is also the record of convictions. And if he wants to unwind it, then it is he who is continuing double jeopardy issues, not the Commonwealth. That being said, I would suggest that McCallop, as I read it, and obviously I defer to the court, and the Foster case that was cited in the defendant's reply brief both permit a more severe sentence, if appropriate, certainly not to punish someone for trying to go to preserve their rights, but they both permit a more severe sentence when a defendant withdraws the plea, if appropriate. And the defendant here got a very favorable sentence considering all the charges that were null prost and the ACCA charge. The defendant makes a good point that his sentence is served, but I think McCallop and Foster say that when a defendant is undoing his plea, he puts himself at risk for not getting the same exact favorable sentence. That being said, I'd like to move first to the issue of the burden. The parties dispute who has the burden in this appeal and on the motion for new trial. The defendant correctly claims that when there is a claim that a plea is insufficient on constitutional grounds, then the Commonwealth has the burden to show that the plea was validly made, the defendant knowingly and voluntarily waived his rights and accepted the plea. And you look at the transcript of the plea colloquy and all the proceedings at the plea and make that determination. And I would suggest that this plea shows the defendant knew what he was doing. He knew the charges and the prior convictions. And he and his counsel said they had talked about the elements. We have no information about whether that discussion was insufficient or not. It's not mentioned in the defendant's affidavit. And appellate counsel notes that she was unable to get an affidavit from plea counsel. So I would suggest on the face of this record, there's nothing to show an involuntary or unknowing plea. What the defendant was challenging and appears to be challenging now is whether Rule 12 was met. And when that's the case, the Commonwealth maintains that the defendant has the burden, and that's Rule 30. He has the burden to show that justice may not have been done. I suggest that that burden has not been met on the serious drug charge by any view of this case. The defendant offered a guilty plea. The prosecutor described it as a distribution of Class B and gave the date and time of the conviction. The defendant does not dispute that there was a date and time of conviction. He disputes what was said there. So after he agreed with those facts by the prosecutor, the judge was inquiring further, and the defendant brought up the school zone offense. And the judge was saying, well, the school zone offense has a possession with intent underlying, and eventually he said, yes, ma'am. And that's at transcript 4/3/2012, pages 24 to 25. So it suggests that is sufficient on Rule 12. And there's absolutely no reason to undo the serious drug offense portion of the ACCA because it was a serious drug offense in 2012 when he did his guilty plea, and it's a serious drug offense now.
Is there such thing as null processing the underlying distribution and only convicting somebody for the school zone? Doesn't the school zone have to be from and after the underlying crime?
I think that's illegal to just have a school zone offense. I'm going to sound like an old lady and I apologize, but back in my day, if they wanted to do something like that, they would do a 1 day on the distribution conviction, and then the sentence would be the school zone, and they do a 2 or 2.5 from and after the 1 day. But I think they're two different offenses. One requires the prior conviction for the underlying charge. So I don't think you can, I think what the defendant is describing is something that's not even legal. So what would be in the BOP is not even legal. So what the judge looked to in the motion for new trial was the docket, the Superior Court docket from Suffolk, that said the BOP is wrong, that the conviction is for the distribution of Class B, which is what the prosecutor proffered in the plea colloquy. So on that point, the defendant has failed to make his claim on his motion for new trial on the serious drug offense.
On the other hand, there is nothing about the ABDW at all.
So I'm gonna put it right out there. This is the hard part of the case. And I don't think that's telling any tales on that. Ashford now requires that an ABDW be proven using a modified categorical approach to show an intentional use of force, and at trial that's to be proven beyond a reasonable doubt. Wentworth is the only published plea case I could find on this, and Wentworth had lots more facts. So as the pushing of someone down on the bed, and that was found to be a sufficient intentional use of force. We have very bare bones. We have the date.
And I think, when you discuss Wentworth, you cite, I think that Justice Cipher cites Carrera or something like that, or Cabrera, about you don't get to challenge underlying facts. That case actually had to do with you don't get a challenge motion to suppress. But then she goes on to say, and to actually look at the underlying facts. So I think you might have been putting a little bit too much weight on that little part from Wentworth. So because as you acknowledge in that case, the plea colloquy on its face had enough evidence for a sufficient factual basis.
Right. Wentworth hurts the Commonwealth's claim here more than helps, but it shows the process that is required and that you still follow Rule 30. And so I don't want to say we're right in the same spot as Wentworth, because we don't have those underlying facts at all. So at the time of 2012, we didn't need them because we had the residual clause, which is now unconstitutional, and later under Widener, that wasn't even in effect at the time of the plea, was found to be categorically a violent offense. And now we know under Ashford that that's wrong. We have to have an intentional use of force, threat of force, or attempt to force. And we don't know any of the facts of this case. So I would point to the—
Are they unknowable?
I don't think they're unknowable. I would point in my brief, and it's an unpublished opinion, so I understand that it has little weight. I want to acknowledge that was my appeal, so I wanted to put that out there as well, that I understand the heavy burden the Commonwealth faces because we lost Conte. But in Conte, the defendant actually came forward and said, hey, look at the plea colloquy from my prior conviction. It shows that I wasn't convicted under the intentional or the use of force. Ashford hadn't come out yet. And the Commonwealth tried to say, well, look at the facts that were presented, that's sufficient to show force, and it was found to be insufficient by this court. In this case, the defendant could have said, he could have offered in his affidavit in support of his motion for new trial, my attorney never discussed use of force and said this was under the residual clause, or ABDW is automatically a violent offense. He didn't do that. They tried to get an affidavit from counsel and got nothing. We can't draw an adverse conclusion from that, but that means we have nothing about that. The defendant has not offered in his motion for new trial, the underlying police report to show what the prior conviction facts were. So that's what we see in Conte, the defendant actually meeting his burden under Rule 30, and here, the defendant not meeting his burden under Rule 30. So I would ask this court to affirm the denial of the motion for new trial. I want to acknowledge the motion judge did not have Ashford. Did not have the benefit of Ashford at that time. If this court disagrees with the Commonwealth, the remedy, I think, is to unwind the whole plea colloquy. If you disagree with me, then I think the remedy would be to reduce the ACCA to one prior conviction and remand it for resentencing. But I think it unwinds the whole plea, the guilty plea agreement.
I have a question for you about the record. This document that the prosecutor gave to the judge at the end of the hearing on the McCarthy motion. And the judge said in his findings and rulings on the McCarthy motion that it was a printout of the Suffolk docket. Now, what the defendant attached to his motion to withdraw the plea was one page of the Suffolk docket. And that page, it said RA 104. That page was printed in 2017, so long after the McCarthy hearing. Do we have anywhere in the record the printout of the Suffolk docket that the ADA gave to the judge and a copy to defense counsel at the McCarthy hearing?
I apologize, Your Honor. I don't know the answer to your question. I focused my attention on the plea and the motion for a new trial, and I only referenced the McCarthy motion to show that the defendant had notice of what his underlying charges were. So I do not know the answer to your question. I apologize for not knowing.
My concern is that this printout from 2017 of the Suffolk docket that's attached to the motion to vacate, for all we know, that the Suffolk docket could have changed maybe, but that's just the first page of the docket with the list of charges. It's not the part of the docket that shows the entry of the plea and the sentencing. So, and it's certainly not a certified conviction. So I'm just wondering, and it's after the fact of the plea. I'm just wondering, what weight should we give to that page of the docket as far as proof of what it was that the defendant was convicted of in Suffolk?
I think I'm a little confused because the motion to dismiss occurred before the plea.
Correct.
So, but the motion for new trial documents that had the Suffolk docket in it were provided by the defendant years after the plea.
Correct.
Mhm.
Correct.
So,
But so my point is, the motion to dismiss that happened before the plea, there's a reference in that in the transcript and in the judge's findings and ruling that he had before him a printout of the Suffolk docket.
right. And
We don't have that before us. And so my point is that hearing and the judge's findings and rulings may have put the defendant on notice as to what the Suffolk charge was.
right. And I think the motion for new trial, my memory is the motion to dismiss judge, the pretrial motion to dismiss judge found that the Suffolk conviction was distribution. And the indictment reads possession with intent to distribute. And he found that that variance did not prejudice the defendant. And so there was no need for dismissal. And so that's why I suggest it puts the defendant on notice. As to that piece of paper, I don't know if it was made part of the record, and I don't recall looking to find out the answer to your question.
One quick question. If hypothetically we were to agree with you as to the serious drug conviction, but not as to the ABDW, what should happen in sentencing?
So the difficult part is that the Commonwealth's position is it unwinds the whole plea if he doesn't want to accept that the plea that was agreed to. But I can see if this court disagrees with me on that, then you reduce the ACCA to one prior conviction and remand it for resentencing.
Thank you.
Okay, well, thank you both. Very, very interesting case. You give us a lot to think about, both of you. So
Are live and on the record.
thank you. Calling the next case, Commonwealth versus Clinton Jennings, 2020 P1338. Attorney Harper Nixon.
Thank you, Your Honor. Good morning. And for the record, Matthew Harper Nixon on behalf of Mr. Jennings. I'd like to start with the sufficiency claim. And as I did in my brief, I'll address first the question of the sufficiency of all the substances in the living room that day. And then in the alternative, address the question of the substances that were in what I'll term the first, the bag that was on the floor. I think this case is a prime example of the caution that the SJC put forth almost 20 years ago in Boria, and the caution of relying on the doctrine of constructive possession to support existing suspicions rather than fostering a fair analysis, essentially creating a circumstance in which the Commonwealth is relying primarily on guilt by presence or guilt by association. When the police entered the door that day at the house in Pittsfield, there's no question that Mr. Jennings was standing in the room. He absolutely was. But the Commonwealth, of course, in order to get over the rail of sufficiency, needed to provide some additional plus factors. That's what Boria and going back to Brown tell us. And here I would suggest to the court that the plus factors are simply not there. During the trial, the two elements that they relied on primarily were the question of the scale and the question of the ottoman. The scale, I acknowledge, is a little bit tricky. The testimony around it is a little unclear even to me after having read the transcripts many times. But I think it's clear that the photographs that were used were showing the scale being on, which would certainly allow a reasonable inference that this was a functional scale that was on the table that day. But as I understand the testimony, the police, in fact, turned the scale on for purposes of taking those photographs. But setting that aside, even if, sorry, just
Well, didn't the police officer testify that the first thing he does when he gets to the scene is to photograph everything before they search? So can't we, in the light most favorable to the Commonwealth, can't we infer that Exhibit 6 that depicts it on was taken before the police turned it on to make sure it worked, which was Exhibit 17 that he talked about?
I don't think so, because as I understand the testimony, both of those photos were taken after it was turned on for purposes of showing that it was functional. In other words, my understanding is Exhibit 17 is really just a close-up of where it was when they took Exhibit 6. Now, I may be misunderstanding that, but let's say for sake of argument that the court finds that. I'm not sure it really actually adds into much of a plus factor. So even if in the light most favorable to the Commonwealth, the scale is on when we get into the room. What that really shows is that this table was being used to package drugs. Frankly, I don't think there's much question about that. When you look at the rest of the evidence of the various indicia there, someone was sitting at that table packaging drugs. What we don't have is any knowledge about how long that scale stays on. I have a postal scale that I've used in my private practice at times to weigh letters. I couldn't tell you today if I turn it on, how long it stays on before it turns itself off, or if it stays on until I turn it off. So if the jury had heard something about it's regular knowledge that these scales stay on for 15 seconds and then turn themselves back off.
Can't the jury make an inference about how long it takes for the ottoman cushion to puff up, and the fact that the ottoman was within arm's length of the purse?
Well, no, actually, and that's the other issue about the ottoman. And I think if there could have been more evidence about the ottoman. It was not presented to the jury, first and foremost. It was left in the room. This is well outside the record, but it's the best example I could come up with. I have a couch. If I sit on the couch for a long time watching sports or watching television, there's an imprint that forms similar to what they're describing here. At some point, it reforms. I couldn't tell you how long that takes. I can't imagine most jurors have really paid attention, to be perfectly honest. Now, we had the police saying that when they walked in the door, they saw it reforming. But how do we know that it had been reforming for the past 20 minutes as opposed to the past 20 seconds, which is, of course, what the Commonwealth wants people to believe? The ottoman requires a chain of inferences. And obviously, sufficient evidence of even constructive possession can be provided with reasonable inferences. And in fact, the Commonwealth doesn't have to provide direct evidence of every element. It can provide circumstantial evidence, including reasonable inferences. But we have these prohibitions and these warnings in our case law about piling inference upon inference upon inference. And I think the term I would use is that at some point the inferences become an assumption. And so the Commonwealth here wants the jury to infer that the ottoman was reforming because someone was sitting on it moments ago, that in fact the person who was sitting on it was in fact packaging drugs, and that person was Mr. Jennings. And so all those links in the chain, I would suggest to the court, at some point can't really hold the weight of the reasonable inference the Commonwealth is asking to draw here. I would also note in the Commonwealth's brief, which was not really a focus of the evidence at trial, but they mentioned the notion of these, what they call dealer blowouts in the upstairs bedroom. Those apparently were found there. It's a little unclear, but I will acknowledge that in the light most favorable to the Commonwealth, the evidence would probably point to the fact that they were found in the bedroom where the other photos were taken. I don't think that really adds much to the analysis either, because these are plastic bags. The dealer blowouts, of course, are what's left over from the plastic bag when you're packaging drugs. And we have no idea how long those bags had been there. They could have been there for days, weeks, months. This does not seem to have been a location that Mr. Jennings had any kind of exclusive control over. He did use the term that he stayed there from time to time, which I think colloquially means that he perhaps was someone who visited. We do have, obviously, we don't have to believe Ms. McIntosh's testimony, certainly for purposes of sufficiency, but she did testify that she was a regular visitor there, and she called him over that day to spend some time together. And I think it's
let me interrupt for a moment.
Sure.
So what would you agree in the light most favorable to the Commonwealth, because that's a standard that we use here, are the facts that support constructive possession?
So in the light most favorable to the Commonwealth, obviously the fact that he is there does offer some support of constructive possession. The problem is that Boria requires more.
Right, so tell me about the plus factors in the light most favorable to the Commonwealth that you agree could be considered.
I don't really see any. I'll be perfectly honest. I'm not prepared to concede that any of these factors are sufficient plus factors. I just feel like even in the light most favorable to the Commonwealth, there's too much question, too many inferences that have to be made for them to offer that support to get the Commonwealth over the rail as to constructive possession of even the substances in the room itself. And as far as the substances in the bag, I think that requires a whole second set of inferences above and beyond what we're talking about with regard to the substances that are sitting on the table.
So if we disagree with you on the first issue about constructive possession, and we say that the reasonable inferences and the light most favorable to the Commonwealth would be that the defendant was the one who was in that area, in essence, packaging at the table. The pocketbook is right down next to the ottoman, correct? Open with the bags.
No. It is right next to the ottoman.
Right.
And so I think that was actually one of the reasons I put the photographs in my brief, and I would ask the court to take a look at that again. When the evidence, according to the police, and this is the evidence that the jury sees, is that the bag is sitting there. There's in this black plastic bag inside the bag. By all accounts, it does appear to be entirely opaque. Then inside that bag are these two large plastic sandwich type bags, I would guess, containing the bulk of the heroin and the cocaine.
Right.
So I know the Commonwealth suggests that it's reasonable for the jury to infer this is sort of, part and parcel of this ongoing drug packaging operation. And obviously, I'm not going to concede that there was sufficient evidence, but assuming the court disagrees with me, I do think we have to have these extra steps to show that Mr. Jennings, frankly, even knew about those substances. They are sitting there in no way, shape, or form in plain view. They're, in fact, a couple of steps away from plain view. And the Commonwealth in its brief referred to the Hamilton case, which I looked at again recently, and I think it's an interesting question. Because in Hamilton, the court found sufficient evidence of constructive possession, but in fact noted that one difference in Hamilton and the facts was that unlike Boria and Brown, in Hamilton, there was apparently nothing tying anyone else potentially to the substances in Hamilton. Here, the Commonwealth's own evidence, and again, I realize that for purposes of sufficiency, we're not taking Ms. McIntosh's testimony, frankly, we just ignore it. It would be my opinion. So the fact that she took ownership of them, fair enough. We don't pay attention to that. However, the only evidence is that these substances are found in this bag, again, within the black plastic bag, with her wallet, with her ID and social security card. So I think any reasonable inference, and I realize reasonable inferences can cut both ways, is that that's her bag, that she, in fact, was the person who possessed those substances. I think it would be different to offer the court a counterfactual if when the police came in and they saw the table with all the packaging equipment and so forth and so on, if those substances had been sitting out on the couch or off to the side on the table, if they had been open, if those bags had been open, that would, I think, be a much stronger indicia of the fact that these were substances that were part of this packaging operation and for their bulk product, for lack of a better way to put it.
You agree, though, that the pictures certainly signify that the pocketbook was open. The bags themselves.
Oh, yes, I'm sorry. The pocketbook was open. Right. I apologize. Yeah, I misunderstood the question. The pocketbook was open there, but the bags themselves were inside this black plastic bag. And so when you look at the open pocketbook, you see only the black plastic bag. You don't see the bags themselves. So I think there was that. Can I ask
you, Attorney Nixon, just given the fact that we have 4.5 minutes left, given your statement that you're not even sure whether the scale was on or off, and in some ways it's a red herring, you're claiming prosecutorial misconduct.
Right.
Tell me why.
Because the prosecutor tells the jury, when you look at those photographs, it tells you that the scale was on when they came in the door. It's a fine point, to be sure. And I think, frankly, the bigger issue on the closing argument is the issue of the conspiring to have Ms. McIntosh lie. But I'll get to that in a moment. But it is a fine point, but I think it matters. And it matters because, assuming, for sake of argument, that the court disagrees with me that there was sufficient evidence here and finds there was sufficient evidence both of trafficking and of possession with intent. I would hope the court would also agree with me this was far from a slam dunk case for the Commonwealth. It was at the very least a close case. And unlike a lot of drug cases, you had someone who came in and took ownership. Ms. McIntosh says to the jury, these are my drugs. Now, for sufficiency, we ignore that. But now we're talking about, will this evidence or will this comment by the prosecutor influence the jury in some way? And I think it's reasonable to think that it would have, because the argument that they're making with these photographs is, look, there's this person who is sitting right there, essentially processing drugs. He's the one who did it. And so,
But
again,
wasn't the prosecutor arguing not just from the photographs, but from the police officer's testimony, that the first thing they do when they get there is to photograph the whole scene before they search? And so therefore, at least one of the photographs of the scale being on was taken before the search.
well, Justice Crandall, if I'm mistaken about that, and if I'm mistaken and the court finds that that's a reasonable inference about that photograph, then obviously that would be appropriate. And I would be wrong about this issue. So if that is the court does find that, I think I would lose on that particular argument.
As far as the argument about concocting the girlfriend's testimony, what do we do with the fact that on cross-examination or during cross-examination of the girlfriend, when there was, I think the Commonwealth was using the jail calls tapes to impeach her, and the judge said at one point, this is at transcript 4, page 107, you listen to the tapes and you get a sense that he's dictating the terms, okay? So it's not out of whole cloth. So aside from the transcript of the tapes, the trial judge who heard the tapes inferred that he was dictating the terms. So why isn't it a fair argument for the prosecutor to make in closing that he was dictating the term?
Well, forgive me, Your Honor, I apologize. I'm sorry, which volume of the transcript was that again?
Volume 4, page 107.
I just wanted to check. My recollection is that was a discussion between the parties, not to the jury. I don't believe that.
Right, no, it wasn't before the jury, but my point is the judge heard the tapes.
Sure, but the jury didn't. And so the issue is the jury has to make a credibility determination based on the evidence before it. And so what they heard from cross-examination from Ms. McIntosh was that these people, or in her direct examination for that matter, these people had a relationship. She cared about Mr. Jennings. They spoke about the case many times, but they certainly never, as I understand, never played for the jury these tapes. If that had been the case, I think this would have been a different matter. I don't think the jury can infer what the judge may have known. And so this commentary about them concocting her testimony, and I see I'm almost out of time, I apologize, I'll try to wrap up quickly. I'll note that the prosecutor never uses the term perjury, but at the same time, it was vital to Mr. Jennings in some ways for the jury to believe Ms. McIntosh's testimony, assuming we had sufficient evidence. Because of course, if they did, he is essentially not guilty. So the prosecutor doesn't say she's committing perjury, but jurors hear people take oaths. They understand what it means to lie to a court. They understand that it means that it's bad to do so. And it's fine for the prosecutor in the context of a credibility determination to explain to the jury that these people are close friends. She may have some bias, but going the step further of saying, now you can infer that they have concocted this testimony. They've worked together to essentially have her come in and not only is she committing perjury, but essentially Mr. Jennings is suborning it. That's what I'm suggesting is a step too far. And I do think it's a prejudicial error in this case.
Okay, any other questions? All right, thank you, Attorney Harper Nixon. We'll hear from the Commonwealth.
Thank you, Your Honor.
And you have to unmute yourself. There we go.
Simple error. Good morning, Your Honors.
Good morning.
My name is Jocelyn McGrath, and I represent the Commonwealth. In this case, there was ample evidence that the defendant possessed all of the drugs in the living room. The Commonwealth did show proximity plus a variety of other incriminating evidence, some temporal, some physical, allowing interlinked inferences, reasonable inferences. The prosecutor's remarks were also proper. There was no error because they're based on facts and evidence, and the inferences based on these facts were reasonable. I think I would turn first to the, I agree with Justice Grant that the scale, there might have been a misstatement in the closing that the scale was shown to be on Exhibit 2, but it actually is Exhibit 6. But the jury are the fact finders, so that isn't really, it's just a mistake. And there is evidence that when the evidence officer came in, he takes overall photographs and he described that process. So I don't think there can be any question that has any significance. The scale itself has both temporal kind of evidence, and it's also a physical object. The cases that we cite in our brief, scales are found off, separated from the person, and not necessarily out in the open, and they still have a significance that of an intent to distribute. That's what the jury heard in the testimony of the officer who was testifying as to the habits of drug distribution. So I would turn to the pocketbook, because the idea that somehow the pocketbook was not related to the drugs found on the table, we would disagree with that. It was a plain view. The purse was seen basically also in the overall establishing shots in Exhibits 3 and 4, and it was open. So basically there's a plain view looking down of an open pocketbook with the plastic dark, the dark plastic bag on top. This can allow an inference that either it was being used as storage for the drug distribution, which Attorney Harper Nixon has conceded someone was distributing drugs there, or it could be there's a reasonable inference that that in the moments before the police entered, someone took that time to put drugs on top, because that's where it was found. It wasn't found at the bottom. It was really kind of placed on top. So it's not necessarily being used as a purse, a personal item. It could be seen, there's reasonable inference that basically the drugs found there were a part of what was happening on the coffee table. There's one of the packages inside the package is a pretty big package. Would you say it was pre, was that coming into the factory or leaving the factory? The drugs that were in the purse, were those about to be processed, or had they already been processed? The drugs that were found in the purse were basically bulk. They were considered bulk. The actual weight of the drugs was considered a bulk amount. The user-sized amounts were actually found on the floor, and the smaller amounts, I think there were 7 or 8 found on the floor. So basically, you can see the difference between what a bulk amount would look like, or it was explained to the jury, and what user size.
So wouldn't the inference be then that whatever's in that bag hasn't been gotten out yet?
Or it had been gotten out and then put back in. I mean, it basically, the open bag on the coffee table is approximately the same kind of size. And there is both cocaine and heroin found on the table and in the bag. So, there's definitely a connection there that can be made, a reasonable inference that the drugs in the purse were part of the distribution of drugs, that was the source.
What was the evidence of the defendant's relationship to the apartment?
There's some evidence. It's not the largest amount of evidence, but basically he said he was staying in the upstairs bedroom. It was stipulated that one of his he has an identification, some sort of identification was found in the kitchen, in a drawer. Basically, there's a poster, a certain kind of love poster that's put on the wall with his nickname on it. And honestly, Your Honor, the exhibits which were shown to the jury, they show a bedroom. They show shoes on the floor. I mean, it wasn't testified to, but in a common sense way, that does look like a bedroom where 2 people are inhabiting it, or at least one person with sneakers. So he did say he was staying there. And so he did not disclaim that he was using a bedroom there. Otherwise, it is that is not the strongest kind of concentration of evidence. The strongest concentration of evidence is its temporal evidence that when the police came in, they were interrupting something because they came through the door so quickly, and that whatever was happening was they were being interrupted. And of course, the items that were found in the room where he was within arm's length. So, I mean, that is really the strongest inferences.
And just to ask you in terms of the closing argument about the concocting the story, you know, there's a line of case that has to do with when you can't just say that a defendant tailored, when a defendant testifies, you can't say that he tailored his testimony because he was sitting here in court the whole time and got to hear the testimony. There's got to be some, you can make that argument if there's actually some basis in the evidence or in the defendant's testimony about what exactly he concocted. So what did they concoct other than her saying they're my drugs? Like, were there other details that you know, suggest there was a concocted story?
Well, the evidence that the officers testified to in terms of what they didn't hear when they were between the knock and announce and the opening the door with the battering ram is that they didn't hear anything. So, and also that they found him standing there. The suggestion that they didn't hear anything is really pretty strong, because her testimony is that there was a certain amount of shouting, some shuffling, you know, Koskinen went up and he came down. So really their stories really at that moment, they don't align at all. They're not compatible. So in a sense, the jury was being asked to decide, you know, which narrative holds together. So even in the fact that they're absolutely incompatible, there is something there. You know, the story is seamless. It gives him an alibi for the time before. It says he didn't know about the drugs at all. He came through a side door. He couldn't have seen them. It even describes why the ID ended up in the kitchen. I mean, I think in a common sense way, people understand when a story is seamless, it is actually kind of raises some questions. So I don't think there's any impropriety in suggesting that that story was made up. And then they had talked quite a bit in the 10 days before trial. And, you know, perhaps she was just, you know, there are other ways of inferring what they were talking about, but she herself said that they were, you know, they're making sure that they understood what happened because they were probably talking about the facts of that night. So, you know, it's absolutely reasonable inference that a jury could hear the testimony of the police officers, hear this testimony, and then come up with a reasonable inference that one of these stories was not correct. I don't think it's actually that complicated. Yeah, she even had an alternate theory as to who was at the table, because as it has been conceded, someone was at that table, someone was distributing those drugs. She suggested that Koskinen was distributing the drugs. So, I mean, the seamlessness of the alibi, I think, is also could be a reasonable inference that something is constructed.
Well, if you have 6 more minutes, but I don't see any questions. If you have anything else you'd like to add?
Not at all, Your Honors.
Okay.
The Commonwealth would stand on our brief. We would like to do that.
Okay. Well, thank you. We'll take the case under advisement.
Are live and on the record.
Thank you. Third case for today is Commonwealth versus Brendan Ray, 2020 P1317, and we'll hear from the defendant.
Good morning, Your Honor. May it please the court. I'm Megan Siddle. I represent the appellant Brendan Ray. I'm here today to ask that the court vacate Mr. Ray's conviction for negligent operation after his Jeep swerved into an oncoming lane of traffic in a tragic accident that severely injured Sean LaVille. The court should vacate Mr. Ray's conviction both because the police did not comply with the strict requirements of the no fix statute, and because no rational fact finder could find that the Commonwealth proved beyond a reasonable doubt that Mr. Ray operated his vehicle negligently so as to endanger the safety and lives of the public. The Superior Court abused its discretion when it did not dismiss the charge of negligent operation after the police waited 56 days to issue a citation, contrary to the strict requirements of the no-fix statute. The Commonwealth argued below that 2 exceptions to the no-fix statute excused a delay of 56 days. First, the Commonwealth argued, and the Superior Court agreed with the Commonwealth on this issue, that additional time was reasonably necessary to determine the nature of the violation or the identity of the violator. Second, the Commonwealth argued that the safety valve exception applied, although the motion judge did not reach the safety valve issue with respect to the negligent operation charge. This court should find that neither exception applies. The motion judge
on whether the delay was unreasonable, you focus on the date of February 12th, and there's some evidence that the reconstruction accident reconstruction officer, the trooper Mahoney, did a visit, or did an inspection on February 12th. Is there any evidence that his report was done on February 12th?
No, we don't know when his report was completed. This wasn't addressed at the evidentiary hearing, but it comes into evidence at trial that the report he finally issues is actually dated August 19th, 2015. He says that's because his supervisor had to approved it on that date, but we don't have any testimony. And again, the Commonwealth has the burden of proving and justifying its delay. We don't have any evidence when Sergeant Mahoney actually completed his report.
But the negligent operation citation issued in March, right?
That's correct.
So the fact that the accident reconstruction report wasn't finalized until August, that actually didn't delay the issuance of the citation here beyond March.
That's correct. And there's nothing in the accident reconstruction process that appears to happen after February 12th. It looks like the only action that Sergeant Mahoney conducts after February 12th is he communicates his conclusions to Detective Campbell at some point in mid-March.
So your calculation of 56 days is the January 23rd to March 20th?
That's correct. And the time period from February 12th until the date the citation actually issues is 36 days.
So is there, what's your best case on that I guess Campbell wasn't diligent enough in calling Mahoney?
I think the best case on that is probably Cara Palucci, which stands for the proposition that even if some delay is reasonably necessary, and to be clear, I'm not disputing that on the night of the accident, the police probably couldn't have issued a citation, but even if some delay was reasonably necessary, the police still have to issue the citation as soon as possible. And I think the biggest issue here is after February 12th until March 20th, there's very little going on. Detective Campbell is working during that time period. He testifies he maybe took a few days off, but he generally was on duty during that time period. He calls Sergeant Mahoney a couple of times. Sergeant Mahoney returns that call a couple of times. I think Detective Campbell actually characterized it as a game of phone tag, but it wasn't a particularly diligent or urgent game of phone tag. And there's nothing in the record explaining why they couldn't have gotten in touch earlier than that. And then even when Detective Campbell does actually manage to get in touch with Sergeant Mahoney, he waits an additional several days. The record isn't clear on how many days he actually waits from when he gets the results of the reconstruction until he issues the citation. But the citation issues on a Friday. He thinks he probably talked to Sergeant Mahoney earlier in that week. And then he says during that time period, he's researching what charges should apply, and he's speaking with his supervisor. Detective Campbell is a very experienced detective. At the time of these events, he'd been on the force for about 14 years. There's no explanation in the record why he would need several days to research a negligent operation charge, which is pretty straightforward, or why he would need to run it by a supervisor.
Counsel, let me just ask you, first of all, this is Whitman Police, correct?
Correct, yes.
So we'll take it for that. not a inner city, downtown area where they're responding often to accidents of this magnitude, correct? You would assume.
I perhaps, I actually don't know from the record, and I'm not that familiar with Whitman personally.
But if we were to accept your argument, in essence, and there was a time in which the defendant went into the station and he was advised that charges probably would be forthcoming, correct?
He was told that charges could be forthcoming.
Right. So he put on some sort of notice, and the purpose of the no fix statute is just what it is, so that there isn't a fix. But the policy, in other words, underlying this would be, you know what, police, whatever you got on the day of the scene, charge as high as you can, and then figure it out afterwards. Because let's just say the accident reconstruction has found that there was something terribly wrong with your client's car that was beyond his control. And there wouldn't be a charge. And he'd talk with his supervisors and say it was a faulty brake system, or if it was something other than that. But what if we agree with you, then doesn't that tell the police to just hurry up and charge with the harshest of charges, and we'll figure it out later?
Well,
seems a little bit against reason.
Well, I think it wouldn't be the court telling police that. I think the legislature has already told police that you have to issue a citation as soon as reasonably possible. Police are entitled to take the time that's necessary to actually conduct the investigation, but they need to do that diligently. And one reason that they need to do that diligently is so that a defendant can actually begin to mount a defense, especially given that motor vehicle violations, the evidence can disappear fairly quickly.
What's our standard of review for the judges? I mean, you know, the judge found that the delay was excusable.
The standard of review is abuse of discretion. And it's my argument that it was a clear error to find that there was that a delay from February 12th through March 20th to play a game of phone tag was reasonable.
Would it be reasonable for the accident reconstructionist to think about it for a while after he observed the vehicle and to do calculations or research?
It could be, yes. But here the Commonwealth has the burden of proving and justifying the reasonableness of the delay. And there's no evidence put forth about what Sergeant Mahoney is doing after February 12th, other than playing the game of phone tag with Detective Campbell.
Can I ask you about the wife's testimony?
Yes.
So you argue that the judge, abused his discretion in letting her testify, and so, but it's assuming we don't find that to be an abuse of discretion. Is that no? I'm sorry. Assuming we do find it to be an abuse of discretion, the judge also immediately told the jurors not to be, instructed them not to be swept by emotions. I mean, do we have to turn that was completely ineffective? That there's just no, that was like an elephant in the room thing. There's no way you can ignore it.
I think that's right, Your Honor. It was highly emotional testimony that was not necessary to any issue in the case. And it also took place on a Friday at the close of the trial day, and the jury went home with that testimony ringing in its ears. At
the end of that day, there was an extra half an hour available, and the prosecutor was ready with another witness, and the defense attorney said he didn't want to have the witness in that half an hour on the Friday afternoon. So can we really hold that against the Commonwealth for it ringing in the jury's ears?
That's a fair question, Your Honor. And I think even if there had been 30 minutes of other testimony, it still would have been ringing in the jurors' ears at that point in time. And I think, jurors are human, and hearing a wife testify about, truly terrible and tragic outcomes for her spouse and for her family, I don't think a juror could ignore that. even after the judge's instructions otherwise.
Are you arguing that there was something wrong about the wife pointing out the victim in the audience in his wheelchair?
I do think that's part of the problem. And I think that the testimony that I think particularly stands out is the testimony about how we couldn't remember her pregnancy, which I think is a very poignant moment that, very human connection with the jury that, I can imagine would have rung true for some of the experiences of the jurors. If their own spouse couldn't remember their pregnancy, that would be a really tragic moment. But I would imagine that the jurors probably already understood that the person in the audience in a wheelchair was probably the victim. So.
If the prosecution had not called the wife and the victim had not been in the courtroom, would the defendant have been entitled to a missing witness instruction?
I haven't considered that question. The defense certainly didn't ask for one. And I don't know that it would have been merited here because there's nothing that would suggest that the victim had a memory of the accident. So, I don't know that there would have been a reasonable inference that the Commonwealth should have called him. And I'll also take a few minutes to address the sufficiency argument from my brief. We do not know what caused the tragic accident in this case. There was substantial evidence that Mr. Ray was actually driving safely up until the very instant of the accident. Witnesses don't report any erratic driving. They don't hear any honking. There's no evidence that either vehicle actually was speeding before the accident, and no evidence that Mr. Ray was in Mr. LaVille's lane of traffic at any point before the instant of the accident. But instead, the Commonwealth asked the jury to infer negligent operation from several circumstances without linking that evidence to any danger to the lives or safety of the public. The first circumstance is Mr. Ray's expired inspection sticker, which is a civil infraction and is not sufficient to prove negligent operation under Texera. And the Commonwealth's evidence does not link the expired inspection sticker to any danger to the public. The second
category, intoxication plus the inspired inspection sticker.
Well, I think the inspired inspection sticker is a red herring. Same with the mechanical condition of the car, which Sergeant Mahoney finds didn't contribute to the accident. There's no evidence showing that the civil inspection sticker or the mechanical condition of the car actually endangered anyone in the public, either in this accident or otherwise. The alcohol is relevant to the question of negligent operation, but alcohol consumption on its own is not sufficient for a charge of negligent operation. The SJC found that in Zagwin. Even alcohol plus a car with some mechanical problems. In Zagwin, the car had a missing headlight, I believe, and the license plate light was out. Even then, that was not sufficient to show negligent operation when there was nothing suggesting that the driver had been operating the vehicle in a negligent manner.
Can I ask you, are you sort of trying to have it both ways? I mean, on the one hand, you're saying there's nothing wrong with the vehicle, but on the other hand, you're saying the reason this accident happened is because something was wrong with the vehicle.
Well, the defense at trial was that the tire came off at the time of the accident. The mechanical problems that the Commonwealth relied on at trial were different. It was, I think they referred to it as Sergeant Mahoney called it body rot or frame rot at trial. So I think those are two different issues. It was clear that the tire coming off was either occurred as a result of the accident or immediately before, because Sergeant Mahoney found that the brake was shiny, so that it was not a pre-existing condition. If there are no further questions, then I will ask that the court vacate Mr. Ray's conviction.
Thank you. We'll hear from the Commonwealth.
Thank you. Good morning, Bridget Norton Middleton for the Commonwealth. I would start with the sufficiency argument. If the court would like to start with a different argument, I'm happy to do that. To start with the sufficiency argument, there were two theories here. The Commonwealth's theory was that the defendant was intoxicated, got into the wrong lane and hit this victim head on, and that it's hit his negligence driving in the wrong lane while intoxicated hits the victim head on. The trooper supports that theory. There's sufficient evidence. He testifies no mechanical problems, there's no braking, there's no swerving. There's evidence in the medical record. So I think there's clearly sufficient evidence on the Commonwealth's theory at trial. But
So
the jury doesn't.
is it enough? Is it enough to say that he was drunk? I mean, does there have to be something else?
Yes, he's in the wrong lane. So is that due care? Is that due care under a negligence standard to be driving your car in the wrong lane and hitting someone head on? So it's different than cases where you just have one factor. There's no evidence of a swerve or a gouge or something jumping in. The trooper said, I can't tell you how long he was in that wrong lane. He's traveling in the wrong lane. No brake marks, nothing, hits the victim head on. So I disagree with my sister that there's nothing else besides intoxication. I think there's quite a bit more than intoxication. I think any of us driving down the road and seeing a car coming at us in our lane, I don't think that's the due care that you're supposed to give other drivers. So that's the Commonwealth's theory of the case. But in terms of the other issues that my sister raises with the condition of the car, the defense theory of the case was that this was an accident, and there was evidence in front of the jury that the defendant told the police officer that his memory was that the tire popped off right before the accident, causing him to swerve. So I think the prosecutor in his closing frames this the best way. And I think Justice Massing, you kind of touched on that. They're trying to have it both ways. So for the Commonwealth's theory, there is enough evidence. But if they reject what the trooper said and credit what the defendant said, and the tire pops off right before the accident, hasn't the defense themselves put the condition of the car into play? And isn't the Commonwealth entitled to argue that, well, under their theory, he's still negligent? Because you get to consider the condition of the car, you get to consider the Mark Lanes violation. In these circumstances, and this gets a little bit into the closing argument aspect of it, I think if asked, the Commonwealth would have been entitled to an instruction from the judge. They could consider the violation of not having an inspection sticker and the Mark Lane violation as evidence of negligence. So, if they credit the defendant, then the condition of the car, and I've cited cases in my brief, the condition of the defendant's car is relevant. And I think when one of the things when you look at the negligence instruction in terms of a civil infraction, they talk about what's the purpose of the civil infraction. The judge did not give this, but in terms of talking about the prejudice of how the Commonwealth argued and whether there was sufficient evidence, I think the court instructs them that they should consider the nature of the civil infraction. Is it meant to protect the public? So in the sufficiency, I think that my main argument is that he's intoxicated and he's in the wrong lane, and I think that's clearly negligent behavior. But in terms of was that evidence admissible, and would it have supported another theory? I think there could be two theories depending on what the jury believed. If there aren't any questions, I'll move on to section 2.
How about section 2? And how do you? It is the Commonwealth's burden to show that Campbell acted with diligence, right?
Yes.
And so how do you explain the month or between February 12th and March 20th?
So it's an abuse of discretion standard for I think Judge McGuire. And the question is, so he doesn't have an answer. There's no evidence that the trooper finished his report or formed his opinion on February 12th. The evidence is that he was waiting for the trooper. He called him, finally connected with the trooper on March 20th. I think the last, in mid-February, you have the detective reaching out, calling 911, reaching out to witnesses. But he mid-March, he finally talks to the trooper, and the trooper gives him a verbal. The report isn't done yet, but he gives him a verbal. And what this officer has been waiting for is what caused this accident. The defendant had told him that his tire popped off. So the officer is waiting to find out, is it true? Did it pop off? And there aren't going to be any criminal charges? Because at the scene, I think that night at the hospital, the officer smelled alcohol, but didn't think that the defendant was drunk. He didn't form an opinion that the defendant was under the influence of alcohol. So the evidence in front of the judge, and it was an abuse of discretion for Judge McGuire to find that issuing a citation on March 20th, where the evidence before him that the detective from Whitman had just received a few days before that, what he was waiting for, in that there was no mechanical problem causing this accident, that it was the trooper's opinion that the defendant being in the wrong lane is what caused this accident. And I think from there we get into, which I think is probably the issue here, is that third exception in the O'Leary case. So is this case different than the O'Leary case? And I think that it is different in some important ways. First, for the purpose of this, the O'Leary's, it was a 9 days. So the officer in O'Leary, I believe it was a state police case, but the officer in O'Leary waited 9 days because the procedure was in that police department that he had to submit the charges and get the approval from his supervisor. Here, that's not the case. Here, it was a few days, and what the officer said is that he wanted to research the charges. After he talked to the trooper, he wanted to research the charges, talk to his supervisors, get some input. And when you see the difference, the factual differences in the two cases, and you consider it in the context of what the purpose, the cases have cited, the purpose of this, the no-fix statute is, I think that in O'Leary, what they talked about is this kind of automatic, this protocol where you have your idea, but what you think happened in a case, you reach your decision, but you have to submit it to a supervisor and wait 9 days, and then they decide what the charges should be, that's exactly what the legislature was trying to end. So what bothered them in O'Leary doesn't exist in this case. In this case, the Detective Campbell did not testify that, well, that's our procedure in Whitman. I don't get to make the call. I investigate it, I wait, give it to my supervisor, and when he gets to it and lets me know. Here it's different, and I think Justice Walsh had touched on this. Don't we want police officers thinking about the case? Do we think that the no-fix statute and that O'Leary stands for the proposition that police officers shouldn't research the charges when a victim was taken by a med-flight helicopter after being cut out of a car in a very serious car accident, a chaotic scene, huge injuries to this victim? And I don't think that that's what O'Leary stands for. And I don't, the purpose of the statute, we don't want to disincentivize police officers from doing some investigation on charges. And here it's a couple of days. And I think that I've cited some cases in my brief that say that couple of days is not enough. So I would have a different approach to the timeline than my sister does. The other difference I would say that in O'Leary, at least my reading of it, what the court really focused on is when they talked about the nature of the accident, O'Leary was a single car accident. And the court, has said, we asked the Commonwealth, is there any single car accident that is serious enough, that would bring you under that exception to the third exception to Section 2. So it's a single car accident, no third party injury in O'Leary. Here we have a head-on crash, not only injuries to the defendant, they almost called the med-flight helicopter for the defendant as well, but then they ended up canceling it. But this victim is unconscious in the car. They got to cut him out of the car, take him by med-flight. There was all kinds of testimony about them securing the scene and trying, maintain the scene, and there was traffic, and it was a very chaotic scene. So I think that those two things are very different between the two cases. Also, I would just point out a couple of other differences. Is in O'Leary, the officer, I think, formed an opinion immediately that the defendant was intoxicated. He thought he was under the influence. Here, Detective Campbell said, I didn't think that, and he wasn't sure about the wheel. So he waited and then did some investigation after getting the causation information. So, I think that the judge was right. And he did not abuse his discretion in finding that the time frame was reasonably necessary for Detective Campbell to investigate the cause of this crash. And I think that when you get into the third exception, that this case is distinguishable from O'Leary, and that that exception does apply, and that it was okay for the detective to issue the citation when he did.
Okay, how is the wife's testimony at all relevant to the issue of the defendant's driving?
So whether a person suffers injuries as a result of an automobile accident, as well as the nature of the injuries, is relevant to the question of the manner of operation was so negligent, and I'm reading, as to endanger the lives and safety of the public. That's the Cohen case. Here, the victim can't speak for himself. The wife can detail the nature of his injuries. They're severe. That's the nature of the case. Assuming that the court finds that there was any prejudice in the wife's testimony, the judge here gave an immediate curative instruction. He gave a curative at the time. I have it laid out in my brief. And also the prosecutor didn't argue this in closing argument. So in terms of prejudice, if the court finds that there is some error in allowing this, and I don't think that there was, but if the court does, I think here the judge alleviated any prejudice to this defendant through his immediate curative instruction and also his final instructions. And also when you look in the context of the entire case, that the prosecutor didn't argue this at trial. The defendant makes a number of objections, some at the time, some on appeal to the prosecutor's closing. If the court doesn't have any specific questions on the closing argument, I would rest on my brief. I think the only thing that I would say in terms of the inspection sticker, if the court found any error in the prosecutor saying it was unlawful to have the car on the road, I would just point out again to the court that had the prosecutor asked for an instruction from the court that this is a violation of a civil infraction and that you're entitled to, consider that evidence. I think in light of that kind of thing, that there would be no prejudice to this defendant.
Can I ask about the
Sure.
actually the judge's instructions? The judge talked at great length about expert testimony, right? And there's a claim that it was an error to characterize Mahoney as an expert.
Yeah. So
the judge, when the judge was talking about expert testimony, who was he talking about?
He's talking about Mahoney, and it was evidence, that he had how many times he had testified an expert in a case. Were
there any other expert witnesses in this case?
No.
There was something about with the blood. There was the blood alcohol, right? Like
yes, they gave a conversion of the blood. I think that was the same officer, if my memory is correct, did a conversion to the defendants of 0.17. The judge also, in terms of, whether you felt like the Commonwealth with, like I said, again, with the inspection sticker, if the court had any trouble with that, the judge gave immediate curative instruction and talked about how I give the law, and, counsel have made some comments, and he was directing them, I think, at defense counsel, but he didn't call defense counsel out. He still gave an instruction. So I think here the judge covered any problem that anyone could find with the evidence coming in with his very, very thorough instructions to the jury. So if the court doesn't have any other questions, I'll rest to my brief. Thank you very much.
Seeing none, thank you both. Both excellent arguments today. And we'll take the case under advisement.
Are live and on the record.
Thank you. The next case today, number 2021 P596, Western Massachusetts Electric Company versus Board of Assessors of Springfield. And we'll be hearing from WMECO first.
Thank you, Your Honor. May it please the court, my name is Dan Finnegan, and I am counsel for the appellant, Western Massachusetts Electric Company. This is an appeal from a property tax decision of the Appellate Tax Board. Decisions of the Appellate Tax Board must be reversed if they are not based on a correct application of the law or if they are not supported by substantial evidence. The Appellate Tax Board committed reversible error in this case by making findings that are not supported by substantial evidence and instead making findings that are based upon misinterpretation of the policies of the Department of Public Utilities. At issue in this case—
Mr. Finnegan, what do we do with the ATV's finding that it had credited certain testimony of Mr. Sansucci as supportive of special circumstances, including his testimony that the Watertown model maybe was always wrong, but there's been a policy change at DPU as to how it treats acquisition premiums? What do we do with that credibility determination?
Okay, well, I don't know that all of that was testimony of Mr. Sansucci. Some of that may have been argument in the papers, but I certainly plan to address each of those special circumstances finding, if I may, and I think I can answer your question in so doing. So If you've read the papers, you know the Supreme Judicial Court has set up a paradigm in these cases that for property tax purposes, the personal property of a regulated utility must be valued at its net book value unless the assessors can sustain a burden. And their burden is to introduce substantial evidence that there are special circumstances that may cause a buyer to pay more than net book value for the property. There's a couple of regulated utility concepts that are extremely important to this analysis. And if I can just briefly have 30 seconds.
Attorney Finnegan, I think Justice Massing had indicated, as he always does, that we've all read the briefs and are familiar with the issues. I was hoping that you would get back with 12 minutes and 43 seconds left to answer Justice Grant's question, which is, what do we do with what it looks like credibility determinations made by the Appellate Tax Board?
Thank you, Your Honor. The first reason why they found special circumstances was this notion that the Appellate Tax Board found that the DPU has abandoned the carryover rate base rule and that utilities have been allowed to recover acquisition premiums. That is the linchpin of the special circumstances finding in this case, and there's simply no evidence that was introduced below by Mr. Sansucci to support that finding. There is not one case that they have cited to, nor one instance since this 1994 mergers and acquisition order from which this stems, that they could point to where the carryover rate base rule has not been applied by the Department of Public Utilities.
So Boston Gas, right? They actually approved this very method, the 50-50 method, based on the very reasoning that the assessors and the Appellate Tax Board keep using. And so that was in 2011, right? And these cases are 2012 and 2013 that are on appeal here.
Correct.
I mean, so really, what changed between 2011 and 2012?
Well, in the Boston Gas case, they specifically noted, it was based somewhat on a vacant record. They specifically noted that once the DPU policy testimony had been put in by the assessors, that the taxpayer could have rebutted that policy, but failed to do so. In our case, we did rebut that policy. We also, in this case, have the benefit of the DPU having filed an amicus brief, which not only shows that everything that the ATB wrote in its decision interpreting DPU policy is incorrect, it directly rebuts any of these notions that they rely on and that the assessors rely on in their briefs, that the carryover rate base rule has been abandoned, or that acquisition premiums have anything to do with the value of the property that we're trying to value in this case.
Well, what they said is that it doesn't affect the rate base. It does, but it doesn't. They also say they figure out other ways to try and get the acquisition cost back to the new owner.
The acquisition premium rule, as they make very clear in this case, is a complete red herring. We are talking about, in this case, the value of regulated utility personal property, hard assets. No one has ever paid an acquisition premium in a transaction that involved just the transfer of hard assets. When hard assets are transferred, and we've cited to two of those such transfers in footnote 1 of our brief, the assets transfer at their net book value. They confirm in this that is all they will allow the assets to do in these transactions. And I would cite to the language that they have on page 3 of their brief, the last sentence the second sentence in the second full paragraph. They say, the department does not allow for an increase in net book value when property is sold, period. It's not a case-by-case determination. There's no exceptions to that. They just specifically say that they do not allow for an increase in net book value when property is sold. That is the carryover rate base rule. It is absolute, and they've applied it in every instance since that 1994 order. Acquisition premiums are something completely different. They're a red herring in this case. They are never paid, as I said, in an asset sale. You will only find those when there are mergers or acquisitions of utility enterprises. Enterprise transactions where entire companies are merged or entire companies are purchased. They tell us on page 4, what is an acquisition premium? Unequivocally, they state it is an intangible asset. Beginning of the second paragraph. When they're involved in a merger or acquisition that results in a premium, they record the premium in a capital account goodwill with a corresponding entry to an intangible asset account. Intangible assets are not taxable as property in Massachusetts. They tell us why the acquisition premiums are paid. They tell us at the bottom of that page, page 4, that what the DPU is trying to do with acquisition premiums is incentivize utilities to create reductions in operation and management expenses that will benefit ratepayers. So they set up the premium as this intangible asset, and they're trying to get utilities to create reductions in savings in operating and management expenses. They tell us how it's recovered. If they can create those savings in operation and management expenses, the utility gets to keep a portion of those savings and apply it towards this acquisition premium, and the rest of the savings go to the ratepayer. That's the entire purpose of it, is to benefit the ratepayer. They also tell us what it is not, most importantly. They repeatedly say in this brief, the acquisition premium does not go into rate base. What goes into rate base is the value of the hard assets, including the personal property that we're trying to value in this case.
But why are the assessors required to use rate base as their tax base?
The assessors are required by statute to assess property at its fair cash value. And that's what we're trying to determine in this case. And the SJC has said for 40 years now that because of the carryover rate base rule, net book value is the fair cash value, because no one would pay more than net book value for assets if you can only earn a market-based return on those assets because of the carryover rate base rule.
I mean, so I don't know why you attached an attorney general brief from a different case to the end of your brief, but you did. And in it, the attorney general explains that Massachusetts courts have determined municipalities can use the hybrid method to calculate utilities property value because the method represents a higher value than net book value, corresponding to the extra value of the utilities assets represented historically by stock sales with prices in excess of book value. Then they say, the AG says the hybrid method is approved in Massachusetts courts because it represents one way in which municipalities can account for the higher value of the company's assets as reflected by stock sales with prices in excess of net book value. I mean, doesn't that explain what the assessors are doing?
No, there was testimony in our case about mergers and acquisition and stock sales, and no, the testimony in the record below shows that what the value of the stock price of a company is not equivalent to the value of its personal property. I think that goes without saying. And again, what the assessors are charged with doing is coming up with the fair cash value of the property. The SJC has said for 40 years that fair cash value is net book value. The only reason they've deviated from it is because of this notion that the carryover rate base rule has somehow been abandoned. The record below again reflects there is not one instance, not one witness got on the stand and testified that in this case the carryover rate base rule has been applied. It has never not been applied. We are now, as we sit here today, more than a quarter of a century out from that rule. It's uniformly been applied. And the Department of Public Utilities has now filed this amicus brief confirming that fact and confirming.
So are you saying that the DPU has not in fact made a policy change?
They tell you right now that the carryover rate base rule has never changed. If you look on page 4 of the amicus brief, last sentence of the first paragraph, they're talking about this 1994 order, and they say the department, however, did not change its rules to allow a buyer to include the acquisition premium and rate base and earn a rate of return of the premium. So in that respect, Your Honor, yes, that's exactly what they say in this brief. They never changed.
What about the SJC cases that are cited in Mr. Klebanov's brief, like the Boston Gas case, and there's the Attorney General v. Department of Telecommunications, where the SJC has said the DPU reversed its previous policy of per se disallowance of recovering an acquisition premium. That's not a judicial recognition of a policy change by DPU?
I don't believe so, Your Honor. Those cases are looking at different records of different cases. We have a record in this case where we did what they didn't do in the Boston Gas case. We put on expert testimony from regulatory experts and from appraisers, which rebutted the notion that this DPU policy had resulted in a change to the carryover rate base. That was not done in these prior cases. That's the difference between the record of those cases and the record of our case.
Attorney Finnegan, you've talked quite a bit about the 40-year history, which is important to us from the SJC. I noticed that you did not cite in your brief NSTAR versus Assessors of Boston, a 2019 appeals court decision, which seems to be similar.
It is similar, Your Honor. That case, however, reflects, again, it's similar, but let me tell you how it's different, actually. It's a different case. That case is involving NSTAR Electric's property in the city of Boston. This case involves Western Mass Electric Company's property in the city of Springfield. In Boston, there was all kinds of testimony that Boston was earning more than its allowed return, and there were opportunities for the utility to grow. In Springfield, it was acknowledged by everybody, including the experts that were put on by the assessors, that Springfield couldn't even earn its allowed return, and there was no opportunity for growth. They had declining customer and usage problems in Springfield. Springfield, we had different witnesses. We did have some of the same witnesses, but their testimony regarding this property was certainly different. And the findings of the SJC, of the Appellate Tax Board were different. In the special circumstances analysis, they found 6 reasons why there were special circumstances in Boston, including this was earning more than its allowed return. In this Western Mass Electric case, they only found 3 things that they could hang their hat on with respect to special circumstances. The primary reason they found special circumstances is this DPU policy that we've been discussing regarding the carryover rate base and acquisition premiums. There were 2 other things they cited to in the Western Mass Electric case, and if I could just address those very briefly. First, they found that because Western Mass Electric Company had a decoupling order, that a buyer may pay more for the property. Again, they're required to make their findings based on substantial evidence. There is not one witness that testified that anyone would pay more for the electric property in Springfield because of the existence of a decoupling order. Just very briefly, what the decoupling order does is the decoupling order tries to deal with the problem of declining usage in an area such as Springfield. What it does is set a target for revenues. The ATB got it wrong just in their decision when they said that the coupling order provides for levelized earnings. It doesn't. It has nothing to do with guaranteeing any level of earnings. It provides for target revenues, which is of course a top line number, earnings being a bottom line number. Testimony was then given that if the decoupling order does anything, it guarantees that the utility could never earn more than its allowed return. And since its allowed return is based on the net book value of its assets, no one would pay more than the net book value of the assets because of its decoupling order. The last thing that was cited was Mr. Sansucci's unsupported statement that utilities frequently earn more than their allowed return. There's no specifics given to that statement. There's no concrete examples that he was citing to, but he did agree with one thing. He agreed that in the years leading up to these cases, Western Mass Electric Company could not even earn its allowed return. It was a utility in an area with declining usage that couldn't earn more than its allowed return. And so even if someone would pay more for a utility that was out earning its return, that situation does not apply to Western Mass Electric Company in this case.
So I see that time has expired. Does anybody else have any other justice have any questions? Okay. Thank you, Attorney Finnegan. We'll hear from Attorney Klebanoff.
Thank you, Your Honor, for the court. I am David Klebanoff. I'm representing the Board of Assessors of Springfield, and I'm asking you to sustain a decision of the ATB, a decision which was somewhat truncated and I think reflective of the exasperation that they had to go through this yet again after the NSTAR case, a case that this court affirmed in all respects and found that the board analyzed exactly as it was supposed to. And you'll see that in this decision, they constantly refer back to NSTAR, both the evidence that was brought in and the findings that were made. What the board sustained was a valuation formula that has been in place for 35 years and has now been adopted as presumptively correct by the Department of Revenue. It came down first in the Boston Edison case, which the SAC affirmed in 1988. It was next used by the Department of Public Utilities itself and affirmed by the Supreme Judicial Court in 1997 in Stowe. It was most thoroughly vetted and discussed.
Can I ask you, Attorney, I'm going to ask you, how do you respond to the appellant's argument that the Stowe case actually supports their position? Because after DPU used the 50-50 method in that case to value the company that nobody's willing to pay that price?
Well, there's more detail to why that deal fell apart, and I didn't put it in my brief because it was part of the record in the other case. I respond to it by saying the significance of the Stowe case, and I'll get to it now, is that despite what the DPU has filed as its amicus brief, they are the first ones that pointed to their change in policy as overcoming the Watertown presumptions. In the Stowe case, they said, the SJC described them as specifically considering its carryover rate-based policy, which has recently changed from a mandatory rule, always limiting a buyer, to the seller's rate base to a case-by-case determination, and concluding that because the carryover rate-based rule might apply to Stowe, Stowe should pay more than original cost, less depreciation. So it's puzzling to see the DPU, who in fact launched this idea that their own change in policy overcomes Watertown, now filing a brief in support of the taxpayer here.
You would characterize their letter as being in support of the taxpayer?
Absolutely, because it's not correct. And in fact, it's troubling in another way. The taxpayer put on evidence, and we put on evidence concerning what the policies are, and they were all contained in written decisions. So in this instance, while I understand that agencies are allowed to sort of explain their regulations in an amicus, this really is evidence in the case. It is not some sort of discussion of what their rules may mean as applied to other facts. And to get it 2 weeks before this argument struck me as frankly a little suspicious, but it's in there. But what it doesn't address is what the courts have focused on exclusively in the past, and that is the change from the ironclad rule to the case-by-case analysis has been held to be certainly sufficient to overcome Watertown. And that somewhat explains why in this case, the board didn't spend a lot of time on it. In Boston Gas, the board discussed this for 108 pages. The SJC spent 25 pages, rebutting all of these arguments that somehow buying an enterprise is different than buying a property. They looked at this idea that there's goodwill and found that there is no intellectual property in a utility. There is no trade name value. This company has been Western Mass Electric, NSTAR, and Eversource just since this began. There is no customer base. It's a regulated monopoly. And so the court concluded that it had not been at all proven that these hundreds of millions of dollars of premiums that have been spent weren't spent for the property. The board was forced to do this again in NSTAR. They spent 84 pages going over all the DPU cases and what they meant. You managed to dispose of the appeal in 4. And now, yes, we have 22 pages, and it is truncated from their prior discussions. And I think it's necessary to go back and see what was seen in the past, because the evidence isn't lacking here. The evidence has become a binding precedent. I believe that's what this court called it in NSTAR. The idea that the DPU policy change has an effect of overcoming the Watertown presumption is not an evidentiary question any longer. This court, as I said, referred to it as a binding precedent. And I think the board took that and allowed itself to dispense with more pages of analysis, which prove that in fact it's correct.
How do you address the, I mean, it seems like there is some appeal to the argument that Springfield's not Boston. That, you know,
Well,
maybe utility property in Boston is worth more than its net book value, but not so in Springfield.
Well, that's a very interesting argument, Your Honor, because what he seems to be saying is that this theory that we've relied on through all these cases going back to Boston Edison isn't necessarily true. That the value is in fact more than net book in Boston. And they talk about Boston having all this, you know, economic boom times and rapid development, and it's led to a higher value. That is really the solitary distinguishing factor between this case and NSTAR. But if you think about what that means, it means that net book and carryover rate base does not in fact limit the value of property to net book. And if you accept that, then the burden becomes theirs to show, okay, so show us how much less in Springfield. I don't dispute that Springfield property may well be worth less than Boston property, but it becomes their problem to show why and how much. And that is something they utterly failed to do with experts that simply took the stand and said, it has to be net book to a mathematical certainty. The same argument they've been making since 1982 in the Watertown case. And the board quite justifiably rejected that because it was premised on misunderstanding that the Watertown presumption had been overcome. And I won't even get into the problems with their valuation witness, who the board essentially found backed into a number that he was told to start with. So I think the fact that they believe that Boston could in fact be worth more than the net book exactly proves the point, that this property has independent value. And to address another point Mr. Finnegan made, that somehow this idea of acquisition premiums don't matter. What an acquisition premium is it's the amount paid over net book for the property. Frequently, it is done by the sale of the company, because if the company is going to sell the property, there's no point for it to exist. There's a lot of tax and accounting reasons. It makes more sense to simply merge. Now, one way we know that they're only buying the property is in several of these cases, they immediately dissolve the company that they bought. So it becomes quite clear that they're simply buying the property, they're buying the territory, they're buying the customers, but it's the property that creates the value. Now, what they also have not denied is that the new DPU policy, in fact, allows them to recover back that amount spent over net book. And if you go back to the original Watertown paradigm, that why would an investor invest money more than net book if he can't get a return on it? He can put it in the bank and get 5%. The fact of the matter is it's not the investor's money anymore. They're collecting it back from the ratepayers. They're acquiring this property just like they acquire all other utility property with ratepayer money. The DPU is allowing them to do that. So the theory of Watertown falls apart. We not only have sales that prove they're paying hundreds of millions of dollars in some cases more than net book, but we have the fact that they're collecting that back. Yes, they're doing it by economies of scale, which permit them to generate savings, but the DPU allows them to keep the savings. They give them specific amounts of money. I think it was $20 million when NSTAR bought Cambridge Electric. They could take 20 million extra every year to pay themselves back for buying it. And that being the case, the logic of the carryover rate base doesn't matter. It does not prevent these sales. We've seen the sales proving it. Just one other point on that. This comment that the DPU has every time enforced this carryover rate base, they've in fact never done it. It has never come up because these are in fact stock sales. The property never transfers from the books of one company to the books of another. It stays on the books of the company that owned it. And Western Mass's own witness, Mr. Reed, admits that. There's a footnote in my brief in which he says that he's unaware of any circumstance where anyone ever requested to have the rate base carried over. And he confirms that none of the sales have been pure property sales. There have been some pure property sales. I cite one in my brief, Great Plain Energy, where the FERC has the very strict carryover rate base rule. It's not only not case by case, but they don't allow a recovery of the premium. And that buyer spent tens of millions of dollars more than net book anyway. So there is in fact evidence that the carryover rate base does not impact, well, I shouldn't say does not impact, but certainly does not limit value to the net book cost of the seller's property. I've discussed why this sort of distinction between Boston and Springfield makes no sense. Insofar as overcoming Watertown, the policy in place at the DPU applies equally to both. It has been determined by the SJC going back for decades that the change caused by the mergers and acquisitions rule was sufficient to overcome Watertown. That being so, the burden then returns to the taxpayer to make some sort of valuation proof. And if they want to prove that something about Springfield makes this property less than net book or slightly more or whatever they want to say, it's their burden to do so. And the board completely rejected all those attempts. And I think you'll find that those determinations are within its jurisdiction completely. So just to wrap it up, it's admitted that some of these points about the ability to pay more than net book, the fact that you can recover it back, this discussion about what's an enterprise value and what's a property purchase, were not discussed in detail in this case, because I think the board simply just relied on what it called the binding precedent and the fact that it was, quote, explicitly affirmed in N-Star for doing exactly the same thing. As I said, the continued unreliability of Western Mass's valuation witnesses is something completely within the board's purview. So what the board did here was consistent with the reasoning and outcome of these cases since 1988. And this court should again perfunctorily affirm the board rather, and hopefully finally convince Eversource that these Groundhog Day appeals year after year, raising the same issues, putting forth the same witnesses, claiming the same things, really ought to come to an end. That's what I have. If you have any other questions, I'm available.
Seeing none, it's a lot of concepts for us to grasp, but your arguments are helpful and the briefs are helpful, so we will take it under advisement.
Thank you very much, Your Honor.
Today in this session, Michelle PUOPOLO versus Commerce Insurance Company, number 2021 P718, and Attorney Forrest for the appellants.
Good morning, Your Honors. And for the record, my name is Michael Forrest. I represent the appellants in this matter. The question before the court is whether or not an insurance company may unilaterally issue its own reservation of rights and unilaterally deduct previously agreed upon actual cash value total loss payments for charges that it itself deems to be unreasonable. This practice occurs despite the fact that the record indicates Commerce exercises a common course of practice wherein, when presented with a storage bill, Commerce will automatically pay that bill in full. The record also establishes that despite the car performance standards, which have been enacted by statute to oversee the actions of the auto insurance industry, that Commerce makes no effort to resist, reduce, or refuse to pay what it deems are unreasonable charges charged to its own insured. Therefore,
let me interrupt for a moment. I mean, what control does Commerce have over independent auto body shops? I understand the standard, but the standard also provides for two different ways, which is alternatives. But in reality, do you think Commerce has any clout with, a small independent place that wants to charge whatever it wants to charge, and they give the option to the insured to move it?
So, Your Honor, I think that we need to take a step back in answering your question. I think that first and foremost, and something that the trial court did not recognize, is that embodying the black letter law is an anti-steerage provision. In other words, what this regulation says is that an insurance company is not allowed to force or direct its insured to a body shop or repair shop. Separate and apart from that, the Commonwealth has allowed these insurance companies to set up EFT programs or early tow programs. Now, an insured is not required to join this EFT program or utilize that shop. However, what Commerce has instituted is a de facto penalty. Despite the fact that there's an anti-steerage regulation in place, Commerce has decided itself, without filing a reservation of rights, without informing the insured, that it will pay in full the bill, this contested third-party liability that Commerce is saying is unreasonable. And rather than fulfill its fiduciary duty to its own insured to defend and indemnify them when it's a covered loss, what Commerce appears to do is just unilaterally, in a single same course of business, just decide if you don't go to their EFT program, where there was obviously an exchange of consideration for a reduced price with these other yards, if you don't go to an EFT program shop, what we're going to do is we're going to pay the bill in full. You will have no knowledge of this, my own insured. But when we negotiate your total loss value, your actual cash value, we'll follow the regulations. And then at the very last moment, we're going to tell you, my own insured, I'm going to reduce your actual cash value payment through my own decision by an amount I already paid to a storage yard, regardless of asking you first. And I think
Is it your position that Commerce should sue the tow yard?
Your Honor, I don't think that that's the question before the court. I think that my position is that the insured, the consumer, is not the person that this falls upon. And I think that the regulation, the statutes, and the performance standards have all been enacted because of a concern that the insureds are constantly put in a lesser bargaining position.
Well,
Why-
how are
why
they,
is
Right, Attorney Forrest, how are they? When I go rent a car, they say, do you want to fill it up with gas for $5.99 a tank, or do you want to do it on your own? And I have a choice, and I make a decision based upon whether I want to pay more or less. Here, anybody driving with a Commerce insurance policy has a choice. They can pay more for storage at the place, but Commerce says, you want to go over to a place that won't cost you a penny? We'll tow it to this place. The insured has choices, and the insured makes a decision. Now, once the insured decides, okay, it's a total loss, I agree, then it's not until that time that Commerce actually owns a vehicle, and to get the salvage value has to pay the bill, whatever it is. They can't negotiate now with any local tow company saying, oh, you charge them $110 a day, but really we all know that 50 is the right amount. Come on, little shop.
So Justice Walsh, I think what's important in this is a misunderstanding about what an insurance company can and regularly does.
Okay.
Regularly, insurance companies negotiate with non-contractual parties for reduced payments. They do it in the PIP world, for example, on a daily basis. They receive a bill from a non-contracted party. They call that party, and just like with the towing regulations as required, they try to either resist, reduce, or they refuse to pay the bill. Now, when they do that, they have taken an affirmative step on behalf of their insureds. The difference between your example at a gas station versus the example at a repair shop is that the average consumer doesn't have regular experience and exposure to repair shops. The average consumer doesn't know what the reasonable and regular rate for storage is. What the insured knows is that my vehicle has been in an accident. My insurance company has told me it needs to go to a storage yard. My insurance company is not allowed to tell me which storage yard to choose. So if I choose one of my choosing, I've done nothing wrong and shouldn't be penalized. But what's happening here is we are writing out the entire section of the non-steerage provisions. And the SJC has addressed this.
Excuse me, if Commerce starts saying to these tow yards, hey, we're going to stiff you, we're not going to pay your bill if we think it's exorbitant, isn't what's going to happen then is that the tow yards are going to start getting rid of the cars sooner that might be salvageable, or they might be evidence of a crime, or they might be something that a plaintiff could use in a personal injury suit?
So, Your Honor, I don't, again, think that that's the question. What Commerce does and what Commerce is supposed to do are two different questions. What the law says Commerce is supposed to do, it's not doing. What the law says Commerce is supposed to do is have a plan in place to resist, to reduce, or to not pay. But Commerce just disregards that duty, and that falls upon the consumer then. The idea here is not to protect Commerce's interests, it's to protect the consumer's interest in this contract. The consumer has done nothing wrong. And I'm sorry,
How do
Justice
you
Walsh.
say that Commerce hasn't done anything? They have an alternative. They say to the owner of the vehicle and the insured, if you want, you can come over to a different place. And the insured makes a determination, as they should have a right to make a decision, whether or not they decide to have their car towed. So why do you say that Commerce hasn't set anything up when it appears that they certainly do have something?
Your Honor, I think we're conflating two things. I think that the EFT, the early tow programs, which are authorized by statute, and the appellants don't disagree, are very different than Commerce refusing, admitting on the record that it does nothing to resist these charges on behalf of its own insureds. If Commerce truly believes that their insureds are being overcharged, just like with medical bills, just like any other thing that they negotiate with non-contractual parties, Commerce has a fiduciary duty to stand up for its insured in this situation. And I would suggest that while not addressed in the trial court's decision, the Goldberg case, the medical malpractice underwriters case, which I acknowledge dealt with an issue of malpractice insurance, but is not the only case from the appellate courts regarding this issue of unilateral reservation of rights. Because in essence, what has happened here is this. As Goldberg Court says, once you've started to pay on a claim, you've accepted and acknowledged coverage. And after that point, unless you had a prior express agreement with your own insured that you were going to seek contribution or you were going to seek some sort of recompense for what you think was unreasonable, that you have to have that agreement. There has been nothing presented in the record through multiple depositions of the appellants, through the adjusters involved in this case, that there was ever a prior agreement before paying what they claim was an unreasonable charge. In fact, I would suggest that the record reflects Commerce disregards its car regulation requirements altogether and instead simply pays the bill in full, knowing full well it's going to penalize its own insured. And so therefore, to suggest that Commerce has done what they were supposed to do, as the appellees suggest, ignores the fact that there are a set of rules that have been put in place. And I'm not going to try to predict or understand why those rules have been put in place for the insurance industry in particular, but the insurance industry has a set of rules and regulations. It has guidelines for how it acts with claims. And in this very case, Commerce...
I'm confused about that a little, because doesn't the car standard, doesn't that apply for the residual market, for people who get insurance on the residual market?
Thank you.
Does that apply here?
It does apply here. And actually, early in this case, Commerce's first defense was that, hey, we did nothing wrong here because we don't have to follow the car standards. It doesn't apply to the voluntary market. But during the course of litigation, their defense changed. They acknowledged, because the Division of Insurance acknowledges, that these car regulations apply equally to both the ceded and the voluntary market. The law is very clear that you cannot treat these two groups of people any differently. So Commerce now acknowledges that the car regulations applied in this very predicament. However, in the same breath, they say, but we didn't do a bunch of them. We did not resist reduce. What we did was there was a separate statute that allows us to negotiate preferred rates with other storage yards. And because we did that, we're allowed to ignore everything over here, including sticking up and defending the rights and liabilities of our own insured. Commerce's testimony in this case evidences that in not only Ms. PUOPOLO's claim, but in Pagan and in Nomi's claims, the exact same similar procedure was undertaken. So I would suggest that when the court looked beyond this and suggested there was an accord and satisfaction, despite there was no consideration given to the insured, or that there had been some sort of agreement prior to the full payment of these purported unreasonable charges, again, the record reflects none of this, that the court erred in dismissing the case. And further, I would suggest that when addressing the issue of class certification of a class that had already been certified, and after testimony elicited from the defendant's agents and adjusters suggests that this is a regular course of conduct, this was nothing particular or individual about my clients in this case, that every time Commerce gets one of these bills, they will pay it in full, and then they will talk to their insured about that, knowing full well that when they paid it in full, they're going to penalize their insured. Goldberg says that you cannot do that. The Goldberg court says that if you plan on seeking contribution, if you are going to seek retribution, or reconsideration for that payment, then you must either file a reservation of rights, you must inform the insured prior to making the full payment, so that there's an agreement prior to this that they will be penalized on their total loss. And just as
I want to ask, can I ask a question? There was actually from the that should have been earlier. Do you agree that the coverage is limited only to reasonable storage costs?
Yes, Your Honor, I do believe that the coverage, but at that same time, the moment they paid the bill without dispute, they were contending on behalf of their insured that that was a reasonable payment, because the insurer can't pay something that's not reasonable. And so once Commerce made that payment, to now suggest that it was unreasonable, again, penalizes the insured. Commerce, if they really thought that it wasn't a reasonable charge covered under the contract, they should not have paid it. They should have done something.
Doesn't paying it mean if they don't pay it, then your clients accrue more costs for longer?
Your Honor, one of the other particulars of this case, which doesn't get a lot of attention, is that every vehicle in this class that had been previously certified was a total loss. So an appraisal on every vehicle in this case has already been done, and the insurer has assessed that this is a total loss vehicle. So this vehicle, in all likelihood, will become salvage, or it will go back to the insurer. So in this case, while I understand Commerce has concerns about occurring storage costs, what they're ignoring is that we have a person who, either through their own fault or fault of another, had a covered liability. They lost the use of that vehicle. That vehicle has now been determined to be totaled. And despite the fact that the contract says that their insurer will defend and indemnify them, their insurer instead decides we're going to ignore what we're supposed to do because it's too hard. We're going to pay the full bill to the storage yard. And then, only then, and afterwards, are we going to penalize our insured. There's been no...
Attorney Forrest, let me back up for a moment. I get into a car crash. They tow it wherever. I like the people where they tow it. They're really nice to me. The car is a total loss. Commerce calls me and says, we've got almost 500 places that we've negotiated a reasonable rate. We can't tell you what the reasonable rate is, but we're telling you we've got under 500. You wanted us to take it there, we will. And no charge to you. And I say, no, I like the car where it's at, even though I know I'm never going to drive it again, etc. And they say, but we got a whole bunch of places 1-2 miles away that we've made inroads, and we have a closed plan, and we have direct payments to them. Isn't it giving the authority to make that decision in the insured hands? It's still the insured car. They can bring it wherever they want. They just suffer the consequences of higher rates if they choose to.
Your Honor, I think that all of that does make sense, except for the fact in this case, the factual circumstances don't reflect your hypothetical. In this case, every bill was paid in full before they talked to their insured. The black letter law says to the insurer, you can't tell people where to go with their vehicle, and you can't penalize them either. And what they're doing with these EFT programs and suggesting that the establishment of these early tow programs satisfies the requirements to defend and indemnify their insureds puts again this onus on, I see my time has expired, Your Honors. Would you like me to finish the question?
Please.
So putting this onus on the insured, unfortunately, again, puts the insured, an individual who is not experienced in the world of auto appraisal or storage, puts them in a position where they think one entity is following its fiduciary duty and looking out for them, while in fact, the whole time, Commerce is more worried about how much money it's going to be able to pull back from its own insured's ACV payment. Thank you, Your Honors. If there's nothing else, I will rest on our brief.
Thank you, Attorney Forrest. We'll hear from Attorney Slotnick. And you should unmute.
Sorry about that. Good morning, Your Honors. Larry Slotnick for the Appellate Commerce Insurance Company. With me today on a separate Zoom window is John Graceffa. The Superior Court in this case correctly ruled that there was no breach of contract. I think that the case requires some context, which I think the court was getting at with their questions to Attorney Forrest. When an insured has been in an accident, they have two choices. They can pick their own body shop, make their best deal, or they can pick a body shop from one of the insurance company's 473 referral shops. A referral shop repair program is codified at 211 CMR 123.06 for the benefit of consumers.
On that question, there's this thing that's just been bothering me about this case. So I get in an accident. I'm upset. My car's in bad shape. I might be injured. How do I know? How do I decide at that point to where to take it? I mean, doesn't it just get towed? I call AAA and they take it wherever. I mean, how do I know? How do I know where Commerce wants me to take it?
Okay, you don't know where Commerce wants you to take it because Commerce doesn't have any say in where you take the car. If you've been badly injured, the police will order a tow. It will be a regulated police tow and regulated police storage. So by statute, police storage is limited to $35 a day. So if you've been badly injured and are in no position to figure out where your car is going to go, the police will arrange for a tow and you will not be billed an unreasonable charge, and Commerce and any other insurance company would pay that charge. The contrasting example would be Ms. PUOPOLO. Her daughter was in the accident. Ms. PUOPOLO went to the accident scene. It was a weekend, and they chose right then and there to where their car was going to go. They took it to a body shop that they knew. They were, it was a friend of a neighbor, a friend of a friend. So those are sort of the two ends of the extremes of your question. If you've been injured, the police will tow it, and you're guaranteed by statute a reasonable rate.
And on the facts of the PUOPOLO case, was there then communication with Commerce about moving the car?
So there are two different programs that Commerce offers. One is the early tow program, where Commerce will offer to take the car and store it during the total loss negotiation process. The other program is the direct repair program, the direct payment plan, sometimes called the referral shop program, where Commerce has pre-negotiated deals with hundreds of body shops. And if you pick one of those body shops, the charges will be reasonable, Commerce will pay them, and you don't have anything to worry about.
But no, just on the facts of on the summary judgment after the PUOPOLOs made a decision where to take it, was there a subsequent conversation with their agent?
There was a conversation between Commerce and Ms. PUOPOLO's daughter, who reported the claim, about the early tow program, and it was declined. As was a referral shop program.
Okay, thank you.
Now, when the insured picks their body shop, again, by regulation, the body shop has to post the rates for storage and for labor rates. So Ms. PUOPOLO was aware of what she was signing on to. And when you bring a car to a body shop, you have to sign a contract with that body shop, an authorization to repair, a direction to pay, because the insurance company is only obligated to pay you, not the body shop. And Ms. PUOPOLO did all those things. So she knew what she was getting into, as did each of these insureds and each of the putative class members. So again, the insured has two choices. They can go with the pre-negotiated shops that Commerce has deals with, or they can go with their own. And if they choose to go with their own, then they are going to live with those consequences. If you choose a referral shop, the costs are pre-negotiated, the repairs are guaranteed for life, and you never pay anything other than your deductible. So this case involves only people who have declined every offer that an insurance company can by law make to them to help save them money, and have chosen instead to pick a different route. And now they want the insurer to bail them out of that choice. Now, the first claim here is that there was a breach of contract. The elements of a breach of contract obviously are a contract, a breach of a material obligation, and damages. The plaintiffs in this case did not present any evidence of any of those elements, and the trial court correctly granted summary judgment. With respect to the 2008 policy, there is no provision at all for the payment of storage charges. We admit that Commerce's practice was to pay reasonable storage charges, but it's not in the policy, and you cannot breach a non-existent provision. With respect to the 2016 edition, Commerce has to pay reasonable and necessary storage charges. Reasonable generally refers to the per diem rate. Necessary generally refers to the number of days. And to prove a breach, the plaintiff must show that the rates they agreed to are reasonable, the number of days were reasonable, and that Commerce failed to pay. That would be the basic elements of breach of contract claim. Here, the plaintiffs have offered no evidence of that whatsoever. They've offered no evidence of what a reasonable charge would be. Commerce, for its part, did offer evidence of reasonable charges. Plaintiffs ignore the provision that says insured does not pay for liabilities assumed by an insured, meaning the insured could agree to pay $1 million a day, but our obligation is only to pay what is reasonable. The plaintiff has introduced no evidence of damages because of what Commerce did. Here, Commerce paid for the value of their car and retired their debt that they contractually agreed to with the body shop, which is something of significant value. The Superior Court correctly ruled Commerce paid what it was supposed to pay and did not breach its contract. The plaintiff's legal argument seems to be primarily the Goldberg case. Goldberg is distinguishable for all the reasons set forth in the brief. It's a different type of insurance. The settlement in Goldberg involved an inchoate liability of uncertain existence and amount, not a contractual debt, with a fixed amount indisputably owed by the insured to an unrelated third party. The settlement in Goldberg was made for the insurer's own benefit to avoid 93A liability. and it involves issues specific and unique to liability policies. Goldberg did not involve storage costs, liens, contractual obligations, recovery of insured property, salvage rights, or any of these things. The same is true for the CareCorps case. These are just cases that have nothing to do with the situation at hand. Similarly, a reservation of rights letter is something taken from the third-party insurance context. A reservation of rights letter is something that is done to prevent an estoppel situation. The case is Salonen versus Paninen from 1947. We don't have an estoppel situation here. The insurance company is not making a representation, nobody's relying on it, and nobody's suffering detriment. So there's no purpose to a reservation of rights letter. The insureds in this case do not cite to any cases that suggest that there's a need for reservation of rights letter in a first party claim like this.
Can I ask you, how do you respond to the plaintiff's policy argument that under the Superior Court's reasoning, say a medical insurer could overpay the provider and then, subtract, then bill the insured for the difference?
I'm not sure where that comes from, and I'm not sure that a medical provider can overbill anyone and then bill the insured. And certainly that was not part of the record or part of the evidence in this case. PIP is I believe Attorney Forrest was referring to PIP.
Yeah.
PIP is statutorily regulated 9034M. There are certain requirements and a body of case law developed around PIP. But I do want to point out one thing in relation to this, which is that the insurance company cannot refuse to pay. That is not an option for an insurance company. If they refuse to pay a valid claim, they will be sued promptly under 93A and 176D. Refusal is not an option for Commerce in this case or for a PIP insurer in a PIP case.
And could you clarify does the car practice policies, do they apply in the voluntary market as well as the residual market?
So
and go ahead.
I'm sorry.
I'd like you to address how that fits into the case.
So the car policies are, it's a bit of a long story because they're a vestige from the days before 2008 when we had a reinsurance facility rather than an assigned risk plan. And in a reinsurance facility, the concern is that an insurance company, once they cede a policy, will have no interest in reducing or resisting any charges because the reinsurance facility is going to pay for it. In an assigned risk plan, the insurance company pays for the claim. So if they don't take steps to minimize the claim, it's the insurance company's problem. So when we switched from the ceded facility to the reinsurance facility in 2008, some of these regulations were vestiges. And insurers argued that the vestigial provisions like this one should not apply to an assigned risk claim. CAR has never come out and said that. No case law has ever come out and said that. So we're not arguing it here, but that's what this is. This is a vestige of history.
What's the word you're using? Ceded?
Ceded to the reinsurance facility.
Okay.
Okay,
thanks. I think enough down that line. Maybe one of the justices has been more pertinent.
So there's a practical issue here, which is that the plaintiffs never explain how an insurer like Commerce could ever reduce or resist the charges here. The plaintiffs have agreed and have a contract with the shop to pay those charges. They've granted a possessory lien to the shops under General Laws Chapter 255, Section 25. So the shop never has to release the car. The plaintiffs own the vehicles. Commerce doesn't own the vehicle. We never own the vehicle until the claim is paid at the end. So we can't repossess the cars. We can't trespass. The cars are not on the streets. The body shops will never compromise their rates. They testify that they will not do so. And Commerce has nothing to offer the body shop in exchange for a reduction in rate. We don't have any business dealing with them. We don't have any relationship with them. The plaintiffs never explain this. And that kind of gets to the fundamental problem here. The the claimants here, the class members, the putative class members, have all the agency. It was their decision to make where they took their body, where they took their cars, and what deal they were going to make. Commerce can't change it. All we can do is have a plan to reduce and resist, and we have two plans. Those two plans are the direct payment plan, which deals with storage rates, and the early tow program, which deals with length of time for storage. The decertification decision by the court was also proper. The standard for a decertification decision is abuse of discretion, and here there was clearly no abuse of discretion. The trial court focused on the accord and satisfaction issue. Obviously, in accord and satisfaction, if there's a disputed claim and the person accepts a compromise settlement, they can't thereafter maintain an action for the unpaid balance. Judge Salinger noted that the accord and satisfaction defense existed for all three named plaintiffs, Pagan, Nomi, and PUOPOLO, and also for an exemplar claim submitted by Commerce. And most importantly, he recognized that every claim would have to be reviewed for an accord and satisfaction defense because it was a possibility every single time. In every one of these cases, and it's clear in the record, there were negotiations between Commerce and the insureds. And Commerce cannot go and take a car until they have reached an agreement with the insured. And by reaching an agreement, they have to explain to the insured what will be paid and what won't be paid. So they have to explain all the various elements of a total loss claim. They have to explain ACV and sales tax and things like that that will increase the amount that gets paid, but they also have to explain the deductions, including excess storage charges. So there's no way that Commerce can actually negotiate and settle up one of these claims without having these discussions with their insureds before Commerce goes and gets the car. And I think Judge Salinger noted that and recognized that this would have to be explored in every single case. We pointed out that there were issues of prior assignments, prior judgments, prior releases, and mitigations of damages.
Before time's up, can I ask if the only reason we would need to reach the class issue would be if we reversed the judgment on some of the underlying counts, right?
I believe that that is correct. I think there was some ambiguity in Judge Salinger's decision as to exactly which counts were dismissed and which ones weren't.
I mean, presumably the case has been dismissed in its entirety at this point.
I believe that is correct, yes.
Otherwise, you couldn't be appealing.
Correct.
Any other questions? Okay, thank you both. Well briefed, well argued cases, and we'll take it under advisement.
We are live and on the record.
Thank you. Calling the last case for this session today, PINECROFT Development Incorporated versus Town of West Boylston, ZBA, 2021 P523.
Good afternoon.
Okay.
May it please the court, George Carizzi, I represent PINECROFT Development, Inc., and an action out of the land court. It's an appeal out of the land court, which involves an appeal from a summary judgment decision which affirmed the West Boylston Zoning Board of Appeals denial of the issuance of an as-of-right building permit under the local bylaw. I know the court has read the materials, so I'll hold off on the facts unless there's specific questions. And I would suggest to your honors that this case involves a situation where the land court deferred to the zoning board on matters where the court shouldn't have. And in doing so, the judge ignored controlling case law and she ignored basic rules of statutory constructions. Preliminarily, I would just suggest that number one, this case involves a split lot. So the case will involve some analysis based on actual use versus abstracted dimensional calculations. And there's a line of cases that deal with what to do with split lots for for whether or not we use the entire lot or whether or not we use only a portion of the lot in split lot situations. The second thing is to remember is that
So why wasn't it the board's determination? Why shouldn't we defer to what the board said about what its own split lot bylaw means?
well, the split lot bylaw that's in place in this town extends the use or extends the regulations from the business zone, the less restricted zone, less restricted zone into the more restricted zone by 30 feet. But when it comes to interpreting the bylaw, when it comes to determining what does the bylaw say, we look to the language of the bylaw. And the bylaw doesn't have the distinction that the board made. The bylaw doesn't deal with lots based on or calculations to the lot line when we determine density. The bylaw says density is determined by lot area. That is the language of the bylaw. So in order for the board to have determined that that calculation goes only to the boundary district, the board had to ignore the use of the word lot when that dimensional criterion was established in the bylaw, because the bylaw says for lot area, 10,000 square feet per unit. It doesn't say area within the boundary, it says lot area. And respectfully, that's the same definition everywhere in town, regardless of what boundary it is. And I suggest that this is a situation very similar to Tobias. It's very similar to Tamboni. When we look at dimensional purposes, when we look at dimensional requirements, those are dimensional. The density is dimensional. And because it's dimensional, we look at the entire area of the lot for compliance. And in this case, the lot has over 40,000 square feet. Because it's over 40,000 square feet, they're entitled to 4 units. That's what the bylaw provides. In order to reach a different result, you have to read the bylaw. You have to read out of the bylaw the word lot. And lot is a noun modifier that's expressly in there to describe what the calculation is. It's lot area. And so the lot being over 40,000 qualifies. And it doesn't stop at the boundary line. And that's been the case since at least 1988. And before, I'd suggest that when we look at zoning bylaws for calculation of compliance, we look at the lot as a whole. When we look to where the actual uses are, we jealously guard the zone. But that's not the case here. With the entire use, the active use, the proposed use of this property for multifamily purposes was 100% restricted to the business district extended by 30 feet.
So can I ask you a question about the Bolter brothers case? And usually I'm not a big fan of underline and bold facing in briefs, but there's one place in Mr. Murray's brief where on page 15, where he underlined and boldface something that's I think is important. He's citing Bolter brothers says, the use of land in one district to meet the dimensional requirements is permissible where it appears both zoning districts permit the proposed active use. And so, in this case, right, the proposed active use is not permitted in the single residence unit, in the single residence zone.
I would agree with that, Your Honor, but I don't think Bolter Brothers is a case in which that was the situation. But remember in Tobias, it's strengthened by the fact that they were there. The decision was correct and strengthened by the fact that that the same regulation was in both districts. The general rule is dimensional requirements go to the boundary line, and it's not whether or not if it's allowed in both districts. I know that's what Bolter says, but I don't think that was the determining factor. They said that dimensional density is lot size requirements are no less dimensional than the frontage requirements, and it just happened to have the same density requirements in both districts. That's not the controlling factor. The factor is whether or not the use or whether or not the use is an abstract, theoretical, mathematical use. Are we using the land to qualify, or are we using the land actually for the business or for the actual use? And there's a whole line of cases when it's an actual use we got that zone.
Can I ask you about that? In this case, so the proposed building, the 4-family thing, goes up to the very corner of the border zone there, but doesn't go into the SR zone at all. So to use that property back there as for dimensional purposes, that means you're not be able to put anything else in the remaining 27,000 feet, right?
Correct.
So that's gonna lay completely unused.
That's completely unused. Fact is, it doesn't lend itself to use, really. I mean, geographically, I know that's not in the record, doesn't, but it doesn't lend itself. It goes up a hill, very, very steep hill. There's a easement, municipal easement on the backland there. It's not a lot yard. It's not going to be used as a park. The house is going with in the business district. And all parking and all driveways. And the reality is, in the business district, you could, under the zoning bylaw, we could actually put the house 10 feet off the road. The idea was to push it back so you didn't have a 10-foot driveway on a busy road. We pushed it back and maximized into the 30-foot district, which, by the way, the zoning bylaw allows. So that was the reason why that was designed that way, Your Honor. I'd suggest that when it comes to looking at where we defer to the boards, we defer to the boards when their decisions are discretionary. So I know the town's brief and most of the court's cases that are cited on the issues of deference, they involve special permits and they don't substitute the judgment of the town when it comes to the discretionary relief. Their decisions, they have discretion there, and so we don't defer. But when it comes to interpreting the bylaw, if the language is clear and unambiguous, then we apply the plain meaning of those words. We don't parse the phrases. We regard every word as having meaning and significance and not being superfluous. And we look at the bylaw as a whole. And it says here, lot area, 10,000 square feet. And in order to reach any other conclusion, you would have to work to come up with, I believe it was the Tamboni court that says a novel construction of the phrase. In that case, it was the yard area. But in this case, they have to come up with a novel construction of the phrase lot area to say, no, the area to the district boundary. And what was wrong there is wrong here. The lot area is the measuring medium.
But are you reading that? So you're looking at section 4.3, which was to lot area. But are you reading it independently of 2.4? I mean, couldn't there be an argument that which has the word regulations in it, that the lot area only extends up to the 30 feet in the more restricted zone?
I would think, Your Honor, the lot area is lot area. I mean, does the lot have this area? I don't think that the requirement, the fact is that we're not extending the use, which use regulations, we're not extending beyond that, but the lot area is still the lot area. Those words apply to both zones, lot area. So it's not as though we're going to, because in order to reach the board's interpretation that under 2.4, that the 2.3, the regular bylaw, when they say regulations, in this unique circumstance, lot area does not mean lot area. It means the area of the portion of the lot in the district. And that is such a stretch because it's not in there. Nowhere in the bylaw is any measurement taken from a district boundary. Everything is always calculated for lot area. Fact is that this lot has to meet the dimensional requirements for 1 acre, and it has to meet the dimensional requirements of 40,000 square feet per unit. If it was over 50,000 square feet, I respectfully suggest that it would meet the 1 acre, and it would meet the 5 units. But we're under 50,000 square feet, so we're capped out at 4, and we still qualify as a building lot. And as long as 100% of the active use is limited to the business portion of this property extended 30 feet, because that's what the judge ruled. And and that issue's not been appealed, and that's consistent with the original building. That's consistent with all the cases so far. We would be entitled to build within that area as long as we don't extend any use beyond that. And it's just used for calculation of density. And I'd suggest that density is dimensional. Dimensional, we use the lot. We use the entire property. And that's as far back as Colray, when they were looking at whether or not it didn't comply with Boston zoning unless you use the neighboring town Brooklines. They said, well, you can use your neighboring town for dimensional purposes, not for active use. And that's what we've got here. We have a dimensional, we're just using the lot for dimensional calculation. And if we're going to defer to the board, because they can apply any interpretation they want, and when we get to court on a Section 17 appeal, we say, what's the board say? If the board is interpreting this way, we're going to defer to them because that's their bylaw. This is in Section 17 office, that's nothing. When it comes to interpreting bylaws according to the plain language, that function belongs to the court, not the board. The board had their chance, and now it's up to the court to see whether or not that interpretation is right. And going way back, in most cases, an erroneous interpretation is not entitled to deference. And when we look to see what is a good interpretation, the Cameron case, is it literally correct? Is the interpretation literally correct? Well, in this case, it's not literally correct. Literally correct, a lot area is the area of the lot. In order to get this, they have to stretch it and say it's not the lot, it's a portion of the lot. So their interpretation is not literally correct, and it fails under the Cameron standard for construction. So I respectfully suggest that the land court had an excellent analysis on split lot, came up to the conclusion everything that this court has said and the courts have said so far that says split lots, we apply the dimensional requirements to the entire lot for abstract purposes, and we jealously guard the zones for active use. Absolutely correct. I think the judge was right. I think she was wrong when she pivoted away from that and said, I will nevertheless defer to the board because this is their interpretation. I don't think there's any support in saying that that you cannot reconcile the two provisions of the bylaw because the words are the same in both. The words are the same for all provisions of the bylaw. Lot area on every lot, not just multifamily, not just single family, not industrial. Lot area can only mean the area of the lot. And I think that's the only interpretation that's supported by the clear language of the bylaw. If there's any questions, otherwise I'd rest on my brief.
Okay, thank you. No, I think we get it. We'll hear from the town.
Good afternoon, may it please the court. Jonathan Murray on behalf of the Zoning Board of Appeals. The fundamental question for this court is, was Judge Roberts, the land court trial judge, proper in deferring to the zoning board's legal interpretation of sections 2.4 and sections 4.3.a? It's the board's position that she was, and I think it's important to frame the standard of review both at Judge Roberts' level and for this court, because that in the board's opinion is the fundamental issue. On a zoning appeal pursuant to Chapter 48:17, a trial judge makes findings of fact de novo and then makes a legal determination based off of those de novo findings of fact, whether or not the board's legal interpretation of the bylaw or its decision was reasonable, supported by the facts, and legally tenable, or was it arbitrary, capricious, and not supported by the facts? If it is legally reasonable, even if a board could come to a different reasonable conclusion, the trial court must give substantial deference to the local board's decision. And that's because the local board, as a policy matter under the Zoning Act, is in the best position to interpret the bylaw, the history of the bylaw, and how it has traditionally been enforced or applied in the town. And so on appeal, the appellate court accepts those de novo findings of fact unless they're clearly erroneous, but they also apply the highly deferential standard. And so the deference here is Judge Roberts deferring to the board on the application of section 2.4. And it's based in the fundamental statutory canons of interpretation, as she puts it. The more specific provision applies over the more broad position, excuse me. And so that is, the board interpreted that that 2.4 allows only the regulation to go 30 feet into the more restrictive area. And listening to my brother's argument, I think it's really important to clarify what's the dimensional requirement at issue here. Unlike the other cases like Tamboni and Teufus and DuPont and Bolter's Brothers, we're not talking about total lot area. It is part of the equation, but what we're talking about here is a density requirement. It's 10,000 square feet per unit in a multifamily building. So theoretically, right now in the business district, this property owner could build a two unit because they have 23,000, but they couldn't build a 4. And the board found, and one of the reasons why the board found that 2.3 was controlling, and I apologize to Justice Mason because I bolded and underlined this in my brief as well. But at 16, the board says, and I'll quote 16 of my brief, I apologize. The board reads section 4.3a of the town zoning bylaw as presupposing that multifamily use is allowed where applicable. As a result, 4.3.a cannot, in the view of the board, be used to expand multifamily use into areas where it is expressly prohibited, including on the instant lot in the 2 zoning districts. And so,
well, but there's not going to be any use at all in the single residence district. That's going to be completely, there's no active, the only use that's being used is using it for the density requirement.
Well, I do not disagree with you, but I think it's important to make the distinction. And as Judge Roberts puts it in her decision, the case law on this is often confusing and sometimes contradictory. But in all of those cases, we talk about dimensional requirements that are in both districts. For example, in the Tamboni case, in the Teufus case, we were talking about side yard setbacks and lot area. Those both existed in both districts. They were both requirements. They were both imposed. But in this case, the facts distinguish from those cases because, as the board found, that requirement is not in the single residential district because the underlying use is explicitly prohibited. So the board made the determination that you can't use that abstract land because it's not available in the residential district. It's not even a requirement because it's expanding the use of prohibited use. And so I think that's how we distinguish those facts. The other reason is the intensity, I think it's easy to overlook, especially in zoning 40A17 appeals, the policy reason and the statutory reason behind the Zoning Act. There are many reasons, but 2 of the relevant ones to this case include decreasing nonconformities and regulating intensity. And what the applicant proposes to do is to use a lot for a land area on a split lot for a use that's not prohibited in the most restrictive area in town, but also proposes a highly intensive use. They could have attained a building permit for a 2-family house as of right under both 4.3a and 2.4, but they decided to do 4. And there's an underlying policy reason why we might regulate intensity. The 10,000 square foot requirement per unit isn't abstract or pulled out of the air. It's based off of planning reasons, site circulation, parking, emergency access, and generally flow to and from the site. And so when we talk about the extension of non-conforming uses and the intensification of the use, that was another reason why the board found that the more explicit 2.4 applied in this case, where we give people some sort of ability to use their lot, but not so much as to infringe on those who are in the more restrictive single residence, or to those other homeowners in the business district who have to then comply with the 10,000 unit. If you continue at that quote that I had on 16 and 17, the board also had found it would affect, if they had granted it, it would effectively reduce the 10,000 square feet for each dwelling unit regulation to less than 6,000 square feet for each dwelling unit. So it's two sides of the same coin, I think. Not only are we introducing non-conforming intense uses into a restrictive area, we're decreasing the requirements, effectively decreasing the requirements in the business district for the multifamily housing. And so my brother talked about the application of the common law rule regarding measuring distances from the either the boundary district or the lot line. And as Judge Roberts found, and I don't disagree, the common law rule generally requires measurements to the lot line, not the boundary line. But as Judge Roberts found, and the rationale why she gave deference to the board is there was a more specific provision. And Tamboni discusses that. Tamboni talks about how the measurements to the lot line, unless there's an explicit provision in the zoning bylaw, and that's what we had here. Although the appellant does not agree with the reasonable interpretation, the trial court judge found that a board could reasonably make either of those decisions. And when that's the case, we defer to the local board and we defer to their judgment and their knowledge of the zoning bylaws. And so, as I stated in the beginning, the standard for this court, at least in regards to the legal issue, is we apply the highly deferential standard that the trial court judge did. And for the reasons I stated and the reasons I have in my brief, I would ask the court to uphold the land court, and I'm happy to answer your question.
I got a couple more questions about your brief. On page 13 at the very top, it says you're talking about the Tophius case.
Yep.
And you say in that case, both districts have the same dimensional requirements, unlike the present case. What is the different dimensional requirements here?
So the 10,000 square foot per unit dimensional requirement, which is required by Section 4, does not exist in the single residential district because the underlying use, multifamily housing, is prohibited. So there is no way to apply that in the single residential because you can't use the uses associated with it.
Okay. And on the next page, you say that Section 2.4 explicitly regulates the extension of dimensional requirements into different zoning districts. Explicitly, or are you saying, or maybe not? If you not quite well, how does it explicitly regulate the extension of dimension requirements?
So 2.4, and I will quote it so I don't misspeak. So it says where, and this is on page 8 of my brief, where district boundary lines divided a lot in a single or joint ownership at the time such line is adopted, the regulations for the less restricted portion of such lot shall extend not more than 30 feet into the restricted portion, provided that the lot has frontage on a street in a less restricted area. And so as the board found, they interpreted that provision, the regulations for the less restricted portion shall extend not more than 30 feet to be the controlling factor.
But I mean, explicitly regulates extension of dimension?
So it was regulations, and so the board
maybe implicitly then.
Sure, and maybe that's poor draftsmanship on my part, and I apologize. But we argued at the trial court that also applied to the use, and Judge Roberts rejected that. But she and the board felt the same, that regulations would include dimensional regulations.
Okay.
And if there's no other questions, I'll rest on my brief.
No, again, thank you both. Very, very well briefed and very well argued on both sides, and a tough and interesting case. So thank you for that. With that, we're going to conclude our session for today. I want to thank the litigants, thank Clerk Ryle for her excellent help all along, and we'll be in recess.
Thank you.